Good, how are you?
I'm well, thank you. This is Miss Wallace approaching to my right, Judge. She's here. We turned in this morning around 3 a.m. on a warrant that was signed by Judge Bunyan.
I did read the warrant.
Just so the court is aware, I've spoken with Detective O'Malley, and he's aware of her turn-in. She's present. I've looked over corrections, inmate sheet. She has no prior criminal history prior to this. Obviously, based upon the charges, and I think the court is probably aware, if they're not, just so I make the record, prior to her turning herself in this morning, she was an elementary school teacher. Obviously, based upon the charges, she's taken a leave of absence from her position. There's also a DCF case plan with her minor children that has been put into place. I've confirmed that with Detective O'Malley. They have placed, they have left the children in her custody, but they have placed her children with her mother in West Palm Beach. She's been living since the incident in West Palm Beach with her mom as well, because obviously she's going to lose her position long-term with the Orange County School Board. At this point, I believe that we're probably going to be resigning our position with Orange County Schools. And so Detective O'Malley has no issues with her relocating to West Palm Beach, living with her mom and her brother. So we're just going to ask that the court voice no objection to her continuing to follow the case plan that shows that. Detective O'Malley stated that when Judge Bunyan signed the warrant, I just received a copy of the affidavit for arrest warrant. Ms. Bush was kind enough to print it and give it to me, but my understanding in the copy of the actual warrant that Detective O'Malley sent to me was that bonds could be set at IAs. What he anticipated was that count one would be set within the bond schedule at the $10,000 mark based upon the lack of her criminal history. He did inform me that he felt like count two would be met at the standard amount of a secondary count, which would normally be the 150, but I think because this resulted in the death, that it has to be at the amount of the bond schedule, which it doesn't show.
I don't think that he has any control over what the bond schedule says, so
Okay.
why don't I call the case first?
Oh, yes, ma'am.
So this is case number 2020 CF 11324, and then, ma'am, can you just state your name for the record?
Yes, ma'am. Kendra Wallace.
Okay, Miss Wallace. And Miss Arnold, have you filed a notice of appearance or intending to do that?
I am intending to do it. My assistant was coming in this morning early, so I don't know if it's made it to the clerk's page electronically.
I don't know, I just asked
Yeah.
because just in case of a bond issue or not being able to make a bond.
There will be an NOA filed.
Okay, so probable cause was found pursuant to a warrant for manslaughter, voluntary or involuntary. At least that's what it says on the front page. So it's an aggravated manslaughter of a child, and count two is neglect of a child. So probable cause was previously found. Ms. Bush, did you want to be heard as to bond? She has no criminal history. I don't think a $10,000
The
bond.
state is not going to make an argument with regard to bond. The state would defer to the court in this matter.
Okay, and so, first, you're not to have any contact, Ms. Wallace, directly or indirectly with the victim's family, okay? All right, and additionally, you're to abide by any DCF case plan that is in place.
Yes, ma'am.
I have no objection, and with her residing in Palm Beach with her mother, she's not being placed on any pretrial release or anything like that. No, I'm gonna add the no weapons, firearms, or any ammunition as a condition of her release. I am gonna set the bond at $10,000 on count one and $150 on count two. And so if there's an issue with the bond, you can file a bond motion with the trial division, okay? Anything further from defense or state?
Nothing from the state, Your Honor. Okay. I'm sorry, Your Honor. The state does have a request. If she has a passport, that the state would request that she surrender
Okay,
the
does
passport.
she,
Yes, ma'am.
do you own a passport, Ms. Wallace?
Yes,
Okay.
ma'am.
So, Ms. Arnold, I don't know if you'll be able to get a hold of that passport prior to her release, but I would just order that it be turned into the clerk's office within 24 hours of her release.
Yes, ma'am.
That gives you an opportunity to get it and turn it into the clerk, okay?
Okay.
Yes, ma'am.
Okay,
Thank you, Judge.
all right.
We have nothing else before the court.
Okay.
May I be excused?
Yes, you may. Thank you so much. Have a great day.
Her mother resides in Palm Beach County.
Is it Palm Beach County, Ms. Arnold?
Sorry.
Can you ask her if it was Palm Beach County? I think she said Palm Beach County. Is it Palm Beach County?
Yes, ma'am.
Okay, I'm just putting that in the order so there's no issues.
Yes, ma'am.
Okay, all right. Thank you, Judge. All right, thank you.
This case.
All right, now
is
I
going to
have,
null
act-
pros,
they rebooted my,
for
my,
an
my
offer
interpreter, so I'm,
of-
let me just see if I can connect.
Actually, at this point,
Okay, should
my offer is going to be. the
Good morning, Your Honor. This is Laura Arroyo, State Certified in Spanish Interpreter, already duly sworn.
Okay, and you said you've been sworn?
Yes, I have.
Okay, thank you. We had some issues with the panel, had to be rebooted, so, I think they're bringing in, you're connecting into the BRC1, and defendant is
Okie dokie.
approaching the podium.
Give me a second, I will
Sure,
connect.
thank you.
My offers
All right, let me know when you've made contact.
for credit time served anyway.
Yeah, it's just it was a null pros one. That's the only reason I was.
None of that was in the record. My offer is going to be the one
Okay,
that.
I just saw the email come
Sí.
up.
Connection is established.
Okay. Good morning, sir. Can you tell me your name, please?
Orlen Ordóñez Canales. Orlen Ordóñez Canales.
Orlin Ordóñez Canales.
All right, Mr. Adornes Canales, you're here in 2020 CF 11391AO. You're arrested for child neglect, and there is probable...
Sorry, Your Honor, I didn't catch what he was arrested for.
Child neglect. I'm
Thank
sorry?
you. And may I ask the deputy to move the mic? I think that's I'm getting interference, and I think that's affecting my ability to hear. Thank you.
All right.
Um,
Do you need me to start over?
No, just with the charge, and I can
Okay.
continue from there.
He's been charged with child neglect. I do find that there is probable cause. He qualifies for the public defender. I don't have a PD
We
form.
didn't get any Spanish form.
Okay. Ms. Felter, do we know if anybody's speaking with,
What we're doing right now, you mean for the affidavit?
I'm just aware, I got an email from your office saying that you all are required to get the PD forms in order for the PD to be appointed, so I'm just making sure I'm not doing anything against what your office wants, so.
No, I wasn't aware of social services. They were doing it over the weekend, so I didn't know if they handed them in or
We
what.
only received the English forms. We did not receive any Spanish.
For the Spanish speaking?
Yes.
Go ahead and do it. I'll handle it on the back
Okay,
end.
that sounds good.
Thank you, Your Honor.
So, sir, did you want the public defender appointed in your case?
Thank you.
Yes.
Okay. I'll appoint the public defender to represent you in all of your cases. Also, you're here in 2020 CT 807AA and 2020 CT 808AA. You're charged with operating a motor vehicle without a valid driver's license and driving under the influence. And there's probable cause for those offenses as well. In 2016 CT 8303AO, you failed to appear for a motion, and the judge did set your bond at $2,500. And in 2016 CT 8302AO, you failed to appear as well, and the bond is set at $2,500. Does he already have the public defender in those cases?
No.
Okay, so the public defender will be appointed in those cases as well. So going back to the first charge, we don't have any witnesses present, Ms. Bush, do you know?
No, Your
Okay.
Honor.
All right, so I am ordering that you have no contact directly or indirectly with any victim or any witness in the case. I'll have you sign the no contact order, sir. Do we have he already signed it? Okay. Did you understand everything on it, sir?
Yes.
You're also to maintain a separate residence. You may return one time with law enforcement to get your personal belongings. You're not to possess or consume any alcohol or any illegal substances without a valid prescription. You're not to drive without a valid driver's license. On the no valid driver's license and the driving under the influence, no drugs or alcohol without a valid prescription, and no alcohol or drugs without a valid, no alcohol or drugs without a valid prescription, no driving without a valid driver's license. Okay, so as it relates to the child neglect charge, the bond is set at $1,000. Bond is set on count 1 of the driving charge at $100, and count 2 will be $1,000. The bonds on the other cases will remain as well. You additionally have an immigration detainer, sir, so that will need to be lifted before you will be able to be released if you do post your bond. If you have questions about that or you need legal assistance, you'll need to contact the public defender. All right, thank you.
I'm sorry, Your Honor, for jumping in. I'm sorry, Your Honor.
Yes.
This interpreter has a very bad connection. I'm struggling being able to do simul as I hear you because there's an interference. It cuts you off. If you don't mind, I'd rather go over the PA because I'm having a lot of difficulties.
Okay, can I try to call
Okay.
back?
Or you could do that as well, whichever of the two.
Okay, will it be you answering or somebody else?
I'll make sure not to answer if you want to do that, or
No,
I
no,
can switch over to the
I
PA,
just
whatever
wanna-
you prefer.
Well, the PA takes a lot longer, so let me try
Okay.
to call back, okay?
Okay, no problem.
Okay.
I will disconnect.
All right, thank you.
I'm gonna try the other one too, Your Honor, that's on this side to see if it works better.
It's usually those headphones that are working and those headphones are not.
Okay.
Did you switch them already, or? Okay, it's usually those headphones that are working.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn.
Okay, thank you. We were previously on with another interpreter and there were some connection issues, so I just want to, we switched the headset out. So I just want to see if that is possibly resolving the issue. So we do have the defendant at the podium. If you could just make contact in courtroom BRC 1.
Thank you, Your Honor. Just a moment. The interpreter is connected, but the interpreter wonders whether the microphone is close enough because the interpreter was able to hear him, but very faintly.
Okay, the other interpreter told us to move the move the microphone away. All right, why don't we try
Ahora
that
te escucho,
again?
sí.
Can you hear him better?
Much better, Your Honor.
Okay,
Thank you.
perfect. All right. Good morning, sir. Can you tell me your name, please?
Giancarlo Rosado Sifonte.
Giancarlos Rosados y Fontes.
All right, sir, you're here in case number 2020 CF 11393AO. You were arrested for burglary of an occupied dwelling, stalking, domestic violence, criminal mischief, over 200 under 1,000, and resisting an officer without violence. I do find that there's probable cause for those offenses. And do we have PD forms for them? or
Not
no?
for Spanish.
Okay. Did you want me to appoint the public defender, sir?
Sí.
Yes.
Okay. I will appoint the public defender to represent you. We don't have any witnesses present, correct?
Oh, correct, Your Honor.
So I am ordering that you have no contact directly or indirectly with any victim or any witness in the case. I'll have you sign the no contact order. Do you understand everything on the order, sir?
Sí.
Yes.
You're also to maintain a separate residence. You're not to return to where the offense is alleged to have occurred. You've been trespassed from there, so you're to abide by any trespass warning. You're not to possess or consume any alcohol or any illegal substances without a valid prescription. You're not to possess any weapons, firearms, or any ammunition. If you have any weapons or any firearms, you're to surrender them within 6 hours of your release. from the Orange County Jail, and you're to comply with any DCF investigation pending. Your bond on count 1 is $5,000, count 2, $500, counts 3 and 4 are $100. All right, thank you, sir. I thought you said we ended up getting this managed. But I thought I heard. Good morning. Can you tell me your name, please?
Eric Donaldo Bonilla Rodríguez.
Eric Donaldo Bonilla Rodríguez.
All right, Mr. Bonilla Rodriguez, you're here in case number 2020 6853AO. You're arrested for domestic violence battery. I do find that there's probable cause, and did you want me to appoint the public defender to represent you, sir?
Sí.
Yes.
Okay. I will appoint the public defender in your case. And we do have a witness here. Ma'am, do you require the interpreter as well? I need a verbal response. So you're shaking your head no.
No.
Okay, I need you to speak up loudly because it's very difficult
No,
to
I don't
hear.
speak English.
Okay, thank you. Can you raise your right hand to be sworn in?
Huh?
Can you raise your right hand to be sworn in?
I need
¿Puede dar
interpreter.
la mano derecha para que preste juramento?
She doesn't.
Your
she-
Honor, she's saying she does need an interpreter.
Oh, she was shaking her head. No, okay.
Yes,
Okay. I think, okay. Can we take the headphones off of him then so that, Mr. Interpreter, I believe the witness needs the interpreter as well, which I think you did hear. I saw her shaking her head no. So, would you be able to do everything over the loudspeaker at this point?
Yes, Your Honor.
Okay.
Thank you.
Please raise your right hand to be sworn in, ma'am.
Levante la mano derecha para que preste juramento, señora.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
¿Jura decir la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
All right, please put your hand down.
¿Puede bajar la mano, por favor?
Tell me your name, please, and spell your last name.
Diga su nombre, por favor, y luego deletrea el apellido.
Jency Barrientos. Barrientos.
Jency Barrientos. Barrientos spelled B as in boy, A as in alpha, R, I as in India, E as in echo, N as in Nancy, T as in Tom, O as in offer, S as in Sam.
All right. And then, Ms. Bush, did you want me to inquire for purposes of this
Yes, Your
hearing?
Honor.
Okay.
Quiero que las preguntas para propósitos de la audiencia, señora Fiscal Bush, sí, su señoría.
How do you know Mr. Bonilla Rodriguez, ma'am?
Señora, ¿cómo es que usted conoce al señor Bonilla Rodríguez?
Es mi pareja.
He's my partner.
And how long have you been in a relationship?
Ya, ¿hace cuánto tiempo que llevan ustedes en esa relación?
Como 9 meses, creo.
About 9 months.
Do you live together?
¿Viven juntos?
Sí.
Yes.
Are you afraid of him?
¿Usted le tiene temor a él?
No.
No.
Do you want to have contact with him through the pending of this case?
¿Quiere usted tener contacto con él mientras transcurre este caso?
No me importa, la verdad, está bien.
It doesn't matter. It's fine, to tell you the truth.
Has there been violence in your relationship in the past?
¿Y en el pasado ha habido violencia en su relación?
No, era la primera vez que pasaba.
No, it was the first time this ever happened.
Do you think drugs or alcohol had any involvement in what happened?
¿Usted cree que lo que pasó fue una cuestión de tragos o de consumo de estupefacientes?
Sí, es que él estaba borracho.
Yes, it happens that he was drunk.
If something like this were to happen again and you felt threatened, would you call law enforcement?
Si algo como lo que ocurrió volviese a suceder otra vez y usted se siente amenazada, ¿usted llamaría a la fuerza pública?
Sí.
Yes.
All right, Ms. Bush, did you have any additional questions?
Fiscal Bush, ¿tiene preguntas adicionales?
No, Your Honor.
No, su señoría.
Ms. Felter?
No, Your Honor.
Perfecto. No, su señoría.
I have one additional question, ma'am. Do you have any concern for the safety of your one-year-old daughter?
Señora, yo sí tengo una pregunta más que hacerle. ¿Usted tiene alguna preocupación o inquietud en cuanto a la seguridad de su hija que solo tiene 1 año?
No,
No.
Okay. Thank you for your testimony, ma'am.
Gracias por su testimonio, señora.
Based on my review of the affidavit, I'm not comfortable allowing contact today, so I'm ordering that there's no contact directly or indirectly with the victim. I'll have you sign the no contact order, sir.
Bueno, basándome en la revisión que acabo de hacer sobre el escrito bajo juramento, yo realmente no me siento cómoda permitiendo que haya contacto de una buena vez. Así que de momento voy a tener que imponer una orden de prohibición de contacto, ni directo ni indirecto, y el señor tendrá que firmar un formulario de prohibición de contacto por ahora.
Do you understand everything on the no contact order?
Señor, ¿entiende todo lo que se refiere a esa orden de prohibición de contacto?
Sí.
Yes.
You're also to maintain a separate residence.
También tiene que mantener sus residencias por separado.
You may return one time with law enforcement to get your personal belongings.
Y se le permitiría que usted regrese una sola vez en compañía de la fuerza pública para recoger efectos personales.
You're not to possess or consume any alcohol or any illegal substances without a valid prescription.
Y también se le prohíbe el uso y la tenencia de alcohol o de drogas a menos que tenga una prescripción médica.
You're not to possess any weapons, any firearms, or any ammunition.
También se le prohíbe la tenencia o porte de armas de fuego, de cualquier tipo de arma o de parque de municiones.
You're also to comply with any DCF or Department of Children and Families investigation.
Y también usted debe cumplir y colaborar con cualquier investigación que esté realizando el Departamento de Niños y Familia en cuanto a este caso.
You also have an immigration detainer, sir, which will have to be lifted before you can be released from the Orange County Jail.
Y también usted tiene una solicitud del Departamento de Inmigración. Y hasta que esa solicitud no se despeje, usted no podrá salir de la cárcel del condado de Orange.
I am going to place you on pretrial release, sir. Make sure you comply with the court order as well as pretrial release.
Así que yo lo voy a poner en libertad provisional. Asegúrese de cumplir con las órdenes del tribunal y con las órdenes que le dé el Departamento de Libertad Provisional.
All right, thank you, sir. Thank you, ma'am, for your testimony today.
Gracias, señor, y gracias, señora, por el testimonio que ha brindado el día de hoy.
Good morning. Can you tell me your name, please?
Braulio Romualdo Miranda Gómez. Braulio.
Braulio
Ajá.
Miranda Gómez.
Miranda, I had Miranda Gomez next. Is this Miranda?
Okay, I didn't know if you had took out Vega Martinez.
Okay, I only had Miranda Gomez next, so. Mr. Miranda Gomez? All right, sir, you're here in 2020 CT 94. You're arrested pursuant to an out-of-county warrant out of Sumter County. The judge in Sumter County did set your bond at none in the case. I am going to appoint the public defender here to represent you. I'm not sure what's going on in Sumter County, but you may be able to resolve this case while you're in Orange County. And so the public defender will be able to communicate with you about the case. You should come back on our docket in about a week or so after we've had contact with Sumter County, okay? Thank you, sir.
Una pregunta.
I have a question.
Yes, sir.
¿El condado es de Ocala? Ajá.
That county, is that in Ocala?
Sumter County, I believe that is north of us. I don't know if it's Ocala.
Perdón,
Anyone know if, where,
Bushnell,
sí,
Bushnell?
sí,
Bushnell?
tuve, estaba trabajando hace como 4 meses allá, me paró el policía y me dieron para que pagara la corte a pagos.
Yeah, I was there 4 months ago doing some work over there. The police stopped me and they gave me a court date to make some payments.
sir, you have this is a violation of probation. So if you're being supervised by probation, it's from the county in which the incident began, okay? So you may be supervised somewhere else, but where Sumter County is where you were placed on probation, okay? So you speak with the public defender. They'll be able to give you legal advice about what to do and what's going on with your case, okay?
Ok, gracias.
Okay, thank you.
All right, thank you, sir.
Hello, how are you?
Good morning.
Good morning,
We
how are
have, is Vega, are you Mr., do we have Leanne Vega Martinez? Okay, one of these is a domestic violence case. Not really sure how she would have bonded. It was not caught by corrections, the neglect of a child.
Came in with a $5,000
Huh?
They came in with a $5,000.
I understand, but usually corrections will look at that and catch that. So, we'll take no action on that, but she should have been required to sign no contact order. All right, so I believe, Mr. Interpreter, can you make an announcement? I don't know if they can hear you out there, because we're having some problems with the speaker, but I'm not sure if anybody out in the gallery needs the interpreter.
¿Alguien más de lo que está entre los auditores que están ahí necesita el intérprete de español? ¿Alguien de la comparecencia?
Can they hear? They still can't hear.
Spanish and English?
okay, because she bonded. Oh, no.
Push it through. Does anyone out there need an interpreter?
¿Alguien de los asistentes necesita intérprete?
Unfortunately, the speaker system something's broken. So,
Understood, Your Honor, sorry.
yeah, so we're having issues.
The response, Your Honor, is no.
Okay, I believe the response is no. If for some reason, we'll call back. Thank you
Very
so
well,
much.
Your Honor.
All right.
You're
have
welcome.
have a great day.
You too, thanks.
All right. Tell me your name.
Hi, my name is George Jorge Arturo Salinas Sanchez. In English, it would be George Arthur Salinas
Okay,
Sanchez.
hold on, sir.
Yes, ma'am.
Yeah, yes. Okay. So, the PD was previously appointed in Ms. Manco's case 2020 MM 3316AO. And, Ms. Felter, did you want to enter a plea of not guilty, and we'll give you a date?
Yes, Your Honor.
Okay.
Division 85, pretrial conference, September 21st at 9 o'clock, courtroom 4A.
All right. And tell me your name again, sir?
My name is George Jorge Arturo Salinas Sanchez.
Okay. All right, you're here in 2020 MM 6769AO, and the public defender was previously appointed in your case.
Okay.
Looks like you were charged.
I was just in somebody's pool.
Hold on, sir. I don't want you to say anything on the record. You have the right to remain silent.
Yes, ma'am.
Everything that you say can and probably will be used against you. This is just an arraignment today. I'm advising you of what the charges are. So the state filed an information charging you with criminal mischief with damage of more than $200, resisting an officer without violence. Those are both first-degree misdemeanors. And trespass in a structure, which is a second-degree misdemeanor. These were alleged to have occurred on or about August 23rd, 2020. And Ms. Felter, how did you wish to proceed?
Your Honor, there's not been an offer made by the state. We'll just go ahead and
there's no offer, then you want to enter a plea of not guilty?
Yes, Your
Okay,
Honor.
we'll give you a date, sir.
I just didn't want to put my hands in the back.
Sure.
Sir, don't
Again,
say any
I
facts, okay?
previously told
Oh,
you
all right.
that everything that this is your arraignment. This is not a trial, this is not a hearing, this is not a time for you to make statements on the record.
All right.
You'll have to contact the public defender, tell them everything that you want to tell them, but I'm not the person that you want to tell,
Okay.
okay?
Division 62 pretrial conference, October 1st at 9:00 a.m., courtroom 9B.
So,
That's
do you
right.
have the number for the public defender, sir?
I have a letter, but I don't know if that's who I have to contact?
Yes,
Yes.
Yes?
yes.
Okay, and
And use
so,
your pen.
can they show me that letter, and can you move me to a place where I'm more comfortable?
Sir, I have no control
I'll have
over
your-
the Orange County Jail and their facility, okay? I can't order them to do
So
anything.
until October 1st, I come back?
Well, you'll have to contact the public defender. They may be able to negotiate a deal with the state, or there may be other motions that they can file on your behalf.
Okay. All right, thank you.
Good morning. Can you tell me your name, please?
Angel,
Mr. Vega?
yeah,
All right, Mr. Vega, you're here in case number 2020 MM 6847AO. You're arrested for domestic violence battery. Do you find that there's probable cause? I'll appoint the public defender's office to represent you in your case. Did we have any witnesses, Ms. Bush?
No, Your Honor.
Okay. Sir, I am ordering that you have no contact directly or indirectly with any victim or witness in the case. I'll have you sign the no contact order. Do you understand everything on the order, sir?
yeah,
All right, you're also to maintain a separate residence. You may return at one time with law enforcement to get your personal belongings.
all right,
You're not to possess or consume any alcohol or any illegal substances without a valid prescription. You're not to possess weapons or firearms or any ammunition. Can he be screened for mental health pretrial release?
Yes, Your Honor, I can.
Okay. So, I'd like you to be screened for mental health pretrial release. We'll see if we can get you in that program. If not, your bond will be set at $500.
I'll be released to what?
Well, you have a $500 bond, or they're gonna interview you and see if you qualify for mental health pretrial release, okay?
All right,
Good morning.
Morning.
Tell me your name, please.
Dwayne Weber?
All right, Mr. Weber, you're here in case number 2020 MM 742AO. The public defender was previously appointed to represent you in your case.
Right.
It looks
I have not
like-
seen him yet.
Okay, well, you'll have to contact them.
Okay.
The state did file an information charging you with one count of violation of a domestic violence injunction or foreign protection order by going to a frequented location within 500 feet. It's a misdemeanor of the first degree, alleged to have occurred on or about August 24th, 2020.
Right.
And my guess is the state does not have an offer today.
There is no offer, Your
Okay.
Honor.
No,
Ms.
Your Honor.
Felter, did you wish to enter a plea of not guilty for Mr. Weber?
We do, Your Honor.
Division 50 pretrial conference, October 5th at 2:30 p.m., courtroom 7C.
All right, sir, and you can contact the public defender, but you will see.
I will.
But you should see a judge on that day.
So my court date now is October 5th?
Yeah, well, that is your next court date.
Thank you, ma'am.
All right. Okay,
Then after him, Mr. Smith, and I have a PD.
okay. Back, PD form.
I have Lee.
But that's fine, it doesn't matter to me. I got the paperwork, so and this is, can you tell me your name, sir?
James Smith,
All right, Mr. Smith, you're here in case number 2020 MM 6846AO. You're arrested for battery. Do you find that there's probable cause? And I will appoint the public defender to represent you in your case. I am ordering that you have no contact directly or indirectly with the victim or any witnesses. You're not to return back to where the offense alleged to have occurred except one time with law enforcement to get your things. So you'll have to maintain a separate residence from the victims. no drugs or alcohol without a valid prescription, and no weapons or firearms or any ammunition. Your bond will stay at $500. I believe there's an out-of-state hold.
Yes, Your Honor.
Okay. Is it a warrant or?
It's an active warrant for a VOP, and that's something classification has to set up to see if they're going to come get them.
Okay, so you do have an active warrant in Indiana, and so I'm not sure if they're gonna place that hold on you. Right now, you do have the hold, okay? All right.
Thank you.
Good morning.
Good morning.
Tell me your name.
Terrence Lee.
Mr. Lee, you're here in 2020 MO 932. You're arrested for disorderly conduct. I do find that there's probable cause. I have a form for the public defender, but before I appoint them and assess fees to your case, was there any offer?
Yes, Your Honor. It's an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, and court costs.
All right. Mr. Lee, did you want to accept the offer?
Yes, ma'am.
Okay. Did you read the plea form? I'm sorry? Okay, do you need a moment, Ms. Felter? I didn't appoint your office, but I don't know.
Yeah.
I said before, I don't want to assess, if he's going to enter a plea today, I'm not going to assess the $50 fee.
Absolutely, Your Honor.
So,
Just wanted to make sure he wasn't on probation and.
I'll ask him those questions. Yeah, no, thank you. Okay, so Mr. Lee, did you read, you said you did not read the plea form?
No, I didn't.
Okay, why don't you read the plea form? I can't accept your plea prior to you reading the plea form, okay? Or I should say prior to you not reading it. All right, why don't we let Mr. Lee have that opportunity to step back and read it, because it may take a little bit of time there, okay? Okay. This was reset, I believe, from Judge Wilson over the weekend. I'm not sure why, because it wouldn't have been a pleable case, but okay, so Mr. Brooks is again mental health in 2020 MM 68338O. I'm going to appoint the public defender. He's charged with battery and petty theft. There's probable cause. And Ms. Felter, did you want to waive his appearance?
Yes, Your Honor.
Okay, so he's not to have any contact with any victim in the case, no return back to where the offense is alleged to have occurred. That's the 7-Eleven at 4690 South Kirkman. Abide by the trespass warning, no weapons, firearms, or any ammunition. The bond on count 1 is $1,000. Count 2 is $100. I'm not taking any action on the out on release case.
Thank you, Your Honor.
Next person going to call is still mental health, Your Honor.
All right. So this was reset from yesterday by Judge Wilson for mental health. 2020 MM 464AA. I'm going to appoint the public defender. Ms. Felter, did you want to waive?
Yeah, sure.
Okay.
Well, go ahead.
All right, so there's probable cause for trespass on property after warning. She's not to return to the Family Dollar at 2614 North Hiawassee Road. Abide by the trespass, no contact with victims or witnesses. I am going to release her on her own recognizance. She's to get can we put in the order? She's to get in touch with the public defender's office within 24 hours of her release. Good morning.
Good morning.
Tell me your name.
My name's Terrence Lee.
All right, Mr. Lee, this is 2020 CT 5814AO. You're arrested for driving under the influence.
Yes, ma'am.
I do find that there's probable cause. I'll appoint the public defender's office to represent you. You're not to possess or consume any alcohol or any illegal substances without a valid prescription. And he's not been screened for pretrial release yet?
No, ma'am.
Your Honor, he hasn't been interviewed.
Okay, so I'm gonna set the bond at 500 or pretrial release if he qualifies.
Ma'am. I'm sorry. I'm so sorry.
I just want, before you start talking.
Okay.
I just need you to understand everything that you say is being recorded.
Yes, ma'am.
And can be used against you.
Yes, ma'am.
If you have a question, you may want to ask the public defender.
I can talk now, ma'am? Yes, ma'am.
Ms. Felter, I don't know if he has a question. I've advised him that he should.
It's not about the case, correct?
Yes, ma'am. It's about I have no criminal history. I've
Yeah.
never been in trouble or anything.
Yeah, that's
Even my
what-
driving record is
Yeah.
clean. This
They're
is my
gonna,
very
they're gonna
first-
screen you for it. That's what
So I
Your
was
Honor
just wondering,
said.
because I have a job, I have to, go to work and get my car out the impound lot and all that stuff like that, but I've never even been in trouble, so that's why I was
Well,
like.
I
if
have convictions here out of state and one here in Florida.
Yeah, that charge got dropped. It was an insurance fraud, and actually, I'm the victim on that.
Sir, I'm
Yes,
just
ma'am.
telling you what I have on the criminal history.
Yes, ma'am.
I've ordered them to screen you for pretrial release to
Yes,
see
ma'am.
if you qualify. If not, you have a $500 bond.
Yes, ma'am. Okay.
Good morning. Tell me your name, please.
Alex Barbosa.
All right, Mr. Barbosa, you're here in 2020 CF 11389AO. You're arrested for battery by strangulation, dating violence, aggravated assault, dating violence, false imprisonment, and battery dating violence. There's probable cause for those offenses. I will appoint the public defender. We do have a witness here. Ma'am, can you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth? I need you to speak out loud and into the microphone.
Yes, I swear.
Okay, you can put your hand down. Can you state your name for me and spell your last name?
Marissa Sanchez, Sanchez.
All right, Ms. Sanchez, thank you. Ms. Bush, did you wish to inquire?
Yes, thank you, Your Honor. Good morning, Ms. Sanchez.
Hi.
Are you afraid of Mr. Barbosa?
No.
How long have you been in a relationship with Mr. Barbosa, and what is that relationship?
3 years we've been dating.
Do you all live together?
Yes.
Does anyone else live in the residence with you?
Yes.
Are there any children in the residence?
No.
And over the course of those 3 years, whether or not it's been reported, has there ever been violence in which you were the victim?
No.
Do you believe that alcohol or any kind of a controlled substance contributed to Mr. Barbosa's behavior?
No.
If something like this were to happen again, strangulation or hitting you or threatening you harm, and you felt that you were in danger, would you call law enforcement?
Yes. Yes.
I have no further questions. Thank you, ma'am.
Ms. Felter?
Do you want to have contacts?
I'm sorry?
You might need to get by the microphone.
Have contact if it was no hostile contact? Would that be something?
Yes.
No further questions.
All right. Thank you, Ms. Sanchez. I appreciate you coming and testifying today. However, based on my review of the affidavit, I'm not going to allow contact today. His attorneys will have to file a motion to allow contact, and that will have to be changed in writing by a judge in the trial division. So, Mr. Barbosa, I'm going to have you sign the no contact order. Do you understand everything that's on it?
Yes.
All right, you're also to maintain a separate residence from the victim. You may return one time with law enforcement to get your things. You're not to possess weapons, firearms, or any ammunition. If you have any weapons, any firearms, or any ammunition, you must surrender them to local law enforcement within 6 hours of any release from the jail. I'm setting your bond and pretrial release as a condition of the bond as well. 1,000 on count 1, 150 on count 2, 1,000 on count 3, and 100 on count 4. All right? Thank you, ma'am. Good morning.
Good morning. How you
Can
doing?
you tell me your name, please?
Patrick Laster.
Mr. Laster, you're here in case number 2020 CF 11390AO. You're arrested pursuant to a warrant. Probable cause was previously found for battery with one prior battery conviction, domestic violence, and false imprisonment. And I don't have a form for the public defender for you. Did you?
I was gonna get I got a private attorney already on another case, and I had spoke with him last night.
Okay, so you do not want me to appoint the public defender?
No, ma'am.
Okay. All right. So, I am gonna, we do have a witness present. And can you raise your right hand, please, ma'am? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And, can you tell me your name and then spell your last name for me, please?
Patricia Manigault. My last name is Manigault.
Okay. Miss Manigault?
Yes.
Okay. And Miss Bush, did you wish to inquire?
Yes, thank you, Your Honor. Good morning, ma'am. What is your relationship with Mr. Laster?
That's my boyfriend, my child's father.
And do you
My
all
kid's
live
father.
together? Do you live together?
Yes.
And your child, how many
I
children are
have
in
two
the
kids.
home?
I have a 2-year-old and an 8-year-old.
And are you afraid of Mr. Laster?
No.
Do you want to have contact with him while this case is pending?
Yes.
And how long have you been in a relationship with him?
Like 10 years.
About 10 years.
Yeah.
Over the course of those 10 years, has there ever been any physical violence, whether or not it's been reported?
No. No.
Do you believe that alcohol or any controlled substance might have contributed to his behavior?
No. It was just a heated argument.
And are you aware that he's been convicted of violent crimes, including domestic violence battery in the past?
Yes.
And that doesn't give you any concern?
No.
I have no further questions. Thank you, ma'am.
Ms. Felter? Oh, I'm sorry, I did not appoint your office. All right, and thank you, Ms. Manigault, for your testimony. I'm not going to allow contact today. His attorney will have to file a motion to modify that at a later date. So, Mr. Laster, I'm going to have you sign the no contact order. Do you understand everything on it?
Yes, ma'am.
You're to maintain a separate residence. You're not to return back to where the offense is alleged to have occurred. You're not to possess weapons, firearms, or any ammunition. Your bond on each count is $1,000 plus pretrial release. Are you gonna be able to make that bond? I know you wanted to hire your own attorney. I
Yes,
just
ma'am.
don't want you, okay, I just don't want you sitting in there without an attorney,
Thank you.
okay?
Thank you,
All
Ms.
right,
Wish.
all
Have a
right.
good day.
Have a good day. Thank you, ma'am.
Thank you.
Good morning.
Good morning.
Tell me your name.
Jamie Pugh.
Ms. Pugh, you're here in case number 2020 CF 113860. You're arrested for burglary of an occupied dwelling with an assault or battery therein, a neglect of a child, open container in a vehicle on a county property, battery, domestic violence, and then a violation of a no contact order as a contempt of court. And there is probable cause. I am going to appoint the Public Defender's Office to represent you in your case. And I don't believe we have any witnesses present. Ms. Bush, count 1 is a punishable by life felony. Does the state wish to be heard as to bond?
Your Honor, at this time, the state is not going to make an argument for holding her at no bond. However, the state would ask the court to take into consideration not only the facts contained within this affidavit, but also the fact that she is out on bond on similar types of charges: battery, domestic violence, battery, criminal mischief with damage more than $200 times 2. And however, I believe, I'm just seeing this note, that that's a diversion case, Your Honor. But the state would ask the court to set bond as to count 1 in the amount of $50,000. Counts 2 through 5, the state would ask the court, or 2 and 3, the state would ask the court to stay the bond on count 2. And 3 through 5 set as subsidiary bonds.
All right, Ms. Felter, did you wish to be heard?
Yes, Your Honor, if the court could take into consideration the financial, she's indigent, she's going to need the public defender, and she's not going to be able to financially afford that. We're asking Your Honor to consider lowering what the state has proposed for the $50,000 and get it within somewhere around a financial where she can bond out and work with her attorneys on this case, Your Honor.
I don't know what is your weekly income, Ms. Pugh? It's very difficult to read it on the affidavit.
Every 2 weeks I get paid around $940.
$940?
Yeah, I have a full-time job. I'm in school and I do have 2 children, so
okay,
having something more affordable would.
So Ms. Felter, she's out on release for DV battery with the same victim, okay?
Yeah, sure.
I'm not going to revoke that release, but I don't think that's an inappropriate bond considering the charge and the fact that it is a life felony.
Sure.
So I don't think it's an inappropriate bond based on those considerations. If she's unable to make that bond, which I have no idea whether she will or not, and be able to communicate with family that may be able to help her. First, before we get to any bond issues, Ms. Pugh, I'm going to order that you have no contact directly or indirectly with any victim or any witness in the case, and have you sign the no contact order. Did you read and understand everything on that order?
Yes, ma'am.
You're also to not return back to where the offense is alleged to have occurred. You're not to possess or consume any alcohol or any illegal substances without a valid prescription. You're not to possess any weapons, any firearms, or any ammunition. You're to comply with any DCF investigation, and you're to comply with the injunction that is in place in case number 2019 DR 005303-0. Your bond on count 1 will be set at $50,000. Count 2 will remain at $1,000. Counts 3, 4, and 5 will be set at $100. I'm not taking any action on the out on release case. It does appear that Mr. Costner, who was working with the Umansky Law Firm, withdrew from your case. Did you want me to appoint the public defender to that case for you?
Please.
Because you don't have an attorney at this time. Okay. So I don't know. Chances are you're going to get removed from that case. From the pretrial diversion based on this new arrest. I don't know, but that's likely what's going to happen. So that way you'll get notice if you have the public defender as to any new court date. If you fail to appear for any court date, you could get a warrant and your bond would be at none likely, okay? All right.
And Your Honor, the state just didn't hear. Was there a no alcohol or controlled substance?
I did, yes.
Thank you.
All right, thank you, ma'am. contact with victims or witnesses. No return. No alcohol, no weapons, DCF. Comply with this injunction.
Okay.
Lee is ready, Your Honor.
Okay, thank you. All right, Mr. Lee, we're recalling your case. And it's 2020 MO 932. You were going to enter a plea to disorderly conduct, and I gave you an opportunity to read that plea form. Did you read it and understand it?
Yes, ma'am.
Did you? And do you have any questions about it?
No.
Okay. Are you on probation anywhere?
No.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yeah.
All right, I do find a factual basis to accept your plea based on the affidavit. In the court file, I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days, time served. Order you pay your court costs by September 21st, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you, sir. Good luck.
All right.
And I did not appoint the PD for him, okay? Good morning. Can you tell me your name, please?
Tony Rogers.
All right, Mr. Rogers, you're here in 2020 CF 11392AO. You're arrested for aggravated battery with a deadly weapon, domestic violence, and aggravated abuse of an elderly or disabled adult with a deadly weapon. And there is probable cause. And I will appoint the Public Defender's Office to represent you. Don't believe we have any witnesses present today. So I'm going to order that you have no contact directly or indirectly with the victim. I'll have you sign the no contact order. Do you understand everything on the order, sir? I'm not sure if you answered me, Mr. Rogers. Did you understand everything on the order?
Yes, ma'am.
Okay. You're to maintain a separate residence. You may return one time with law enforcement to get any personal belongings that you need. You're not to possess weapons, firearms, or ammunition. You're not to possess or consume any alcohol or any illegal substances without a valid prescription. Your bond on count 1 is $5,000. Count 2 is $150. And it looks like you do have a 5-day hold at this time because of being on the probation, okay? So I don't know when that will be lifted, if before 5 days or not, okay? Good morning.
Good morning.
Can you tell me your name?
Angel Santos.
Mr. Santos, you're here in case number 2020 CF 11376AO. You're arrested for aggravated assault with a deadly weapon, aggravated assault on a pregnant person, and assault domestic violence. I do find that there's probable cause, and I'll appoint the public defender to represent you in your case. And I don't believe we have any witnesses present, so I'm going to order that you have no contact directly or indirectly with any victim or any witness in the case. I'll have you sign the no contact order. Do you understand everything on the order, sir?
Yes, ma'am.
All right, and that will have to be changed in writing by a judge prior to having any contact. You're also to maintain a separate residence. You may return one time with law enforcement to get your things. You're not to possess weapons or firearms or any ammunition. I am going to place you in pretrial release with a bond as well. So count 1 will be $2,500. Count 2 will be $150. Count 3 will be $100. Thank you, sir. Good morning.
Morning.
Tell me your name.
Samuel Earl Sr.
All right, Mr. Earl, you're here in 2020 MM 6854AO. You're arrested for battery, domestic violence. I do find that there's probable cause, and I'll appoint the public defender to represent you in your case. And I don't believe we have any witnesses present, so I'm ordering that there's no contact directly or indirectly with any victim or any witness in the case. I'll have you sign that no contact order. Do you understand everything on the order?
Yes, ma'am.
All right. You're also to maintain a separate residence. You're not to return back to where the offense is alleged to have occurred. Do you have items still at that location?
I had pretty much everything packed and in the rental car. We're down on vacation.
Okay, are you going back to get
Well,
anything there?
Just the rental car because we're supposed to fly back Wednesday, but with a no contact order, I'm gonna probably have to drive the rental car back.
Okay, do you need to go back into the?
No,
hotel? Okay.
not into the resident
Okay.
part, no.
Okay, so.
Just back to the
If
parking
for some
garage.
reason you need to go back in there, whatever, you can go with law enforcement.
Yes, ma'am.
Okay? You are not to possess or consume any alcohol or any illegal substances without a valid prescription, no weapons or firearms or any ammunition. I have no idea whether Department of Children and Families was contacted. I don't know how old the child was. I don't want you to say anything, but there's just nothing in the affidavit indicating the age of the child or that DCF was contacted. So, but if there is an investigation pending, you have to comply with that. And where are you living?
I live in New Hampshire, ma'am.
Okay, so I'm gonna order you into pretrial release, with no objection to you going back to New Hampshire, okay?
Okay.
Just so pretrial is aware of that. I think I have to say that now, so. All right, so just make sure you keep in contact with the public defender. Don't miss any court dates that you're required to be present for, okay? Or virtually.
Oh, virtually, okay,
So things are changing rapidly all the time. so.
absolutely.
All right, thank you.
Thank you.
I mean, it's. And the authorized he lives out of state. He lives out of state, so I don't know why that would be the verbiage. He doesn't live here, so I'm authorizing him to move somewhere where he already lives.
Oh, okay.
The verbiage from pretrial services doesn't make any sense to me.
I know, I guess,
Because he already lives in New Hampshire, so I'm ordering him to be able to live where he already lives. I think it should be, I'm allowing him to return back to his yeah, to move back to where he lives in New Hampshire.
yeah, I guess they wanted it on record to make sure that it was noted and stated that he lives out of state.
You
just
can't,
so-
yeah, I mean, I ordered them to maintain a separate residence, but I'm allowing him to leave the state. I'm gonna have to talk to Sandy about that, okay.
So defendant is authorized to return to residence.
Return to New Hampshire to where he resides.
Okay. Thank you.
Okay, that makes more sense. All right, please tell me your name.
Griselda Fuentes.
All right, Ms. Fuentes, you're here in 2020 MM 6844AO. You're arrested for domestic violence battery. Did you find that there's probable cause? I don't have a form for the public defender. Are you intending to hire your own attorney?
No, ma'am.
Okay, did you want me to appoint the public defender? Is there a reason why you didn't?
I didn't know there was battery. I thought it was just domestic violence. Is that the same thing?
Yes.
Okay. Yes, ma'am, that's fine. I didn't know I needed
For-
one.
I have to ask you some questions, okay?
Yes, yes, Your Honor.
So, are you employed?
I'm sorry?
Are you employed? Do you work?
Yes, ma'am.
Where do you work?
I work for OCI, Overland Construction.
Okay, and then are you paid weekly, bi-weekly, or monthly?
Weekly.
And then how much is your paycheck after taxes?
After taxes, $1,500.
So 1,500?
Yes,
Do you have
ma'am.
any children?
No, ma'am.
And do you have any other dependents?
No, Your Honor.
Okay, so 1,500
Weekly.
weekly.
He doesn't qualify.
Okay, you're not going to qualify for the public defender, okay?
Okay, that's fine, ma'am.
So you're going to have to hire an attorney or revisit this issue with the trial judge if the case gets filed on, okay?
Yes, Your Honor.
So I don't believe we have any witnesses. I am ordering that you have no contact directly or indirectly with any victim in the case. I'll have you sign the no contact order. Did you understand
Honor.
everything on the order, ma'am? Did you understand everything on the order?
Yes, Your Honor.
Okay. You must maintain a separate residence. You're not to return back to where the offense is alleged to have occurred. You're not to possess weapons or firearms or any ammunition. Your bond is set at $500. Are you going to be able to make that bond? And my guess is with the income that you make that you would.
Can I get into like my holdings? I could bond myself out as long as I can get to my holdings. Yes,
I
ma'am.
believe that they'll let you get in.
No, ma'am, it's card.
I don't know how that will work.
The bondsman.
The bonds, you'll have to call a bondsman, okay?
Yes, Your Honor.
Okay. All right, thank you. Good luck. Good morning.
Good morning.
Tell me your name, please.
Jasmine Johnson.
All right, Ms. Johnson, you're here in 2020 MM 685180. You're arrested for domestic violence battery. I do find that there's probable cause. I'll appoint the public defender to represent you in your case. And I don't believe we have any witnesses present today. I am ordering that you have no contact directly or indirectly with any victim. I'll have you sign that no contact order. Do you understand everything on the order, ma'am?
Yes.
You're to maintain a separate residence. You're not to return back to where the offense is alleged to have occurred. You're not to possess any weapons, any firearms, or any ammunition. If you have any weapons or any firearms or any ammunition, you're to surrender them within 6 hours of any release from the Orange County Jail. You're also to comply with any Department and Children and Families investigation that there is pending. Your bond is set at $500. All right, thank you, ma'am. Good morning.
Good morning.
Tell me your name, please.
Willie Earl Rankin Jr.
Mr. Ranking, you're here in 2020 MM 684980. You're arrested for battery, dating violence. I do find probable cause, and I'll appoint the public defender to represent you, and I don't believe we have any witnesses present. I am ordering that you have no contact directly or indirectly with any victim or any witness in the case. I'll have you sign that no contact order.
Mhm.
Do you understand everything on the order, sir?
Yes, ma'am.
Okay.
We're here.
You're also to maintain a separate residence. If you need to return back with law enforcement to get personal belongings, you can do so one time. You're not to possess weapons or firearms or any ammunition.
I ain't do nothing to the girl, man. We just had an
Right, sir.
argument.
I'm not saying that you're guilty of anything. I've just said I found probable cause based on the affidavit. So if you have defenses, you'll need to talk to the public defender about that. So I am setting your bond at $1,000.
Well, I won't be going to work 'cause I ain't got no money. I spent all my money on my rent.
And
And
you're
I ain't
out on
did nothing.
release in 2020 CF 7600AO. I am going to revoke the bond and set that at none. I'm not taking any action on the CT cases that he has outstanding, that he's out on release for. So I'll take no action on those, but I am revoking and setting the bond at none. It looks like you do have an attorney in that case. So you'll have to contact them about filing a bond motion for you. All right, good morning. Tell me your name.
Jermaine Robinson.
Mr. Robinson, you're here in 2020 MM 817AW. You're arrested for battery domestic violence, assault domestic violence, and battery. And there's probable cause. I will appoint the public defender to represent you in your case. And I am ordering that you have no contact with any victim or witness in the case. I'll have you sign the no contact order.
Yes, ma'am.
Do you understand everything on that order?
Yes, ma'am.
All right, you're also to maintain a separate residence. You may return one time with law enforcement to get your things. No drugs or alcohol without a valid prescription, and no weapons or firearms or ammunition. And the Department of Children and Families may have an investigation pending, so if they do, you must comply with any investigation.
Yes, I spoke to the lady last night.
Okay, just make sure that you comply with what they are requiring you to do.
Yes,
Your
ma'am.
bond is set at $500 on each count.
Thank you.
Good morning, tell me your name.
Emilio Thomas.
All right, Mr. Thomas, you're here in 2020 MM 6852AO. You're arrested for domestic violence battery. I do find that there's probable cause, and I will appoint the public defender. We do have a witness. Ma'am, can you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
And I can't hear anything you're saying. It's okay, you can keep the mask on, you just gotta get close to the microphone. Okay, tell me
Yes.
your name and spell your last name.
Yolanda, and my last name is Ikner.
Okay. And, Ms. Bush, did you wish to inquire?
Thank you, Your Honor. Good morning, Ms. Eichner. What is your relationship with Mr. Thomas?
I'm the mother of his child.
And are you afraid of him?
No, I'm not.
Do you want to have contact with him while this case is pending?
Yes, I would.
Do you all reside at the same residence?
Yes.
And how old is your child?
He's 8.
And does anyone else live in the home with the three of you? Are there other children?
No.
Do you have any concerns for your safety or your child's safety?
No, I do not.
Do you have any concerns about the 8-year-old witnessing violence between his parents?
No.
Or her parents?
No, I do not.
If something like this were to happen again, would you call law enforcement?
Yes.
And I'm sorry, I'm not sure if I asked you, how long have you been in a relationship with Mr. Thomas?
We'll have to say it's been about 10 years. Over 10 years.
Over 10 years. And over the course of those 10 years, whether or not it's been reported or prosecuted fully, has there ever been violence in your relationship?
No.
I have no further questions. Thank you, ma'am.
Ms. Felter?
I guess, would you say this is out of character for your boyfriend?
Yes. I think he was upset. He was upset.
He was upset. But this is out of the. Is it out of the normal behavior? Nothing further, Your Honor.
All right, thank you. Thank you, Ms. Eichner. I appreciate you being here. Based on what the child told law enforcement, I'm not comfortable allowing contact today. And so I am going to order Mr. Thomas that you have no contact directly or indirectly with the victim or any witness at this time. And that will have to be changed by a judge in writing at a later date. Do you understand everything on the no contact order?
Yes.
Okay, you're to maintain a separate residence. You may return with law enforcement one time to get personal belongings. You're not to possess weapons, firearms, or any ammunition, and you're to comply with any DCF investigation. And I'm going to place you in pretrial release. Make sure you comply with the court order as well as pretrial release, okay? Thank you, ma'am. All right, tell me your name, sir.
Kazi Vicaudin.
All right, you're here in case number 2020 MM 6848AO. You're arrested for domestic violence battery. I do find that there's probable cause, and I'll appoint the public defender. And we do not have any witnesses present. I'm ordering that you have no contact directly or indirectly with any witness or victim in the case. Do you understand everything on the no contact order?
Yes.
You're to maintain a separate residence. You may return one time with law enforcement to get your things. You're not to possess weapons or firearms or any ammunition. I'm placing in pretrial release. Make sure you comply with the court order as well as pretrial release, okay? Yes. All right, good morning. Tell me your name.
Aristotle Papanikolaou.
All right, sir, you're here in 2020 CT 3372AO. You failed to appear for a pretrial conference. The judge did set your bond at $1,500. Does he have the public defender? If not, I'll appoint them. You did fill out a public defender form. Either way, I'll appoint them if you don't already have them, okay? If you can't make that bond, you're gonna have to contact them to file a motion with the trial judge, because I can't change or modify that, okay?
Okay.
Okay, you did not have the public defender, so they're now appointed to represent you. I have Battle. I don't, whatever you want to do, it's just, that's the arraignments.
Yes, okay.
It's fine. I'm just going by what's next in my stack. Whatever is easier for you. Okay. All right, so we'll do the arraignment. So Mr. McGee, you said is medical? Okay. And so that's 2020 CT 565480, and the PD was previously appointed in the case. And Ms. Felter, did you want to enter a plea of not guilty?
Yes, Your Honor.
Okay.
Division 62, pretrial conference, October 1st at 9:00 a.m., courtroom 9B.
All right, good morning. Can you tell me your name?
Yoash Errol, Your Honor.
Okay, Mr. Errol, you're here in 2020 MM 2018E.
It is final.
The PD was previously appointed in your case, and there was an information filed alleging a petty theft with a prior theft conviction, which is a misdemeanor of the first degree, and a trespass in a structure, which is a misdemeanor of the second degree, and these were alleged to have occurred on or about August 10th, 2020. I'm showing 43 days. And was there a resolution?
There was an offer conveyed, Your Honor.
There is an offer conveyed. May I, for one moment, speak to the client?
Sure.
He's under the impression there's a call off her.
With what case? I did not.
I didn't see him.
I didn't either.
Just wanted to check, make sure. Your Honor, we're going to go ahead and enter not guilty plea at this time.
Okay.
Division 81, pretrial conference, September 24th at 9:00 a.m., courtroom 4E.
Next person, Your Honor, you have Jonathan Black?
I have Kyle Bendel on this?
It's bonded out, Your Honor.
Bonded? Okay, we'll take no action. And then next is Mr. Black.
Is medical, Your Honor?
Okay, so the PD was previously appointed, 2020 MM 6002AO. It's a domestic violence case. Ms. Felter, did you want to enter a plea of not guilty?
Yes, Your Honor.
Division 50, pretrial conference, October 5th at 2:30 PM, courtroom 7C.
Do you have Garcia Diaz?
I had a Jatavius Hamilton.
Medical, Your Honor?
Okay. And so the PD was previously appointed in 2020 MM 407AA. And Ms. Felter, did you want to enter a plea of not guilty?
Yes, Your Honor.
Okay.
Division 81, pretrial conference, September 24th at 9:00 AM, courtroom 4E.
Then I had a Jackson. Huh? Is this Mr. Jackson? Okay. All right, state your name for me, please.
Cortez Lorenzo Bernard Jackson.
Okay, Mr. Jackson, you're here in 2020 MM 5473 AO. It doesn't look like the public defender was previously appointed for you. This is a summons case, and you were served with the summons. Are you requiring them to fill out affidavits are you guys speaking with the people who are set for arraignment?
If, I have no problem, there is an offer in the case, but without.
Okay, I just wasn't sure. So
Yes.
I don't know if
know,
y'all are meeting with the people, because not everybody has the public, has.
Absolutely, and I saw all the emails last week, so we're having to go through and make sure that they're getting the affidavit signed.
Okay, so he has no credit for time served, because it's a summons. So I don't know what the offer is, or it's a petty
Your
theft
Honor.
with a prior theft conviction.
It was a 30-day offer with no days credit time served.
Are you on probation?
Ma'am?
No. Are you here on something else, obviously?
Yes, ma'am.
Okay. And have you been sentenced on that case?
I'm actually waiting to go to court. I was taking 2 years probation on that case.
Okay. I don't know if you, I can appoint the public defender and you can discuss the offer with Ms. Felter to see if you wanted to take it. I don't know if you plan on being here for 30 days. If it's beneficial to you, I can't give you any legal advice. So, but the state's offer is, did you say an adjudication of guilt with 30 days? And you don't have any credit for time served. Was everything returned?
No, Your Honor, this is a restitution case.
Okay.
Restitution in the amount of $230.63. Cost of investigation to the Orlando Police Department in the amount of $335.30. And this would come also with a no contact, no return, and abide by trespass warnings.
Okay, so that's the state's offer. And then I would also have to explain to you, theft, any theft is an enhanceable offense. So now you've got a petty theft, and because you've been previously convicted of theft, they've charged it as a first-degree misdemeanor, as a petty theft with one prior. This, if you pled to this, that would give you 2 prior petty thefts. So if you commit any type of theft, they could charge that as a felony with petty theft or, with 2 prior convictions. So, Ms. Felter, do you want to talk to him about it?
Sure.
Okay. And so I'll appoint the public defender. Do you have the PD on your other case? Do we know what his other case is?
Your Honor, he's here on multiple cases.
If he had the PD, then I would just appoint them without an affidavit. And Ms. Felter seems to be communicating with him, so I'm gonna appoint him. What do you guys want to do?
He's gonna accept the offer, Your Honor.
Okay, all right. So, Mr. Jackson, I did appoint the public defender in the case for you, and you had an opportunity to talk with Ms. Felter. Did she answer and explain everything that you wanted to know?
Yes, ma'am.
Okay, do you have any additional questions?
No, ma'am.
Okay, and did you read the plea form?
No, I haven't.
Okay. Why don't we get you a plea form? And then I'll let you step back there, and I'm going to handle the next case, and then we'll come back to you. I'll give you an opportunity to be able to read it thoroughly, okay? All right, tell me your name.
Dontavius Rozier.
Do you know what happened to Vassal?
Vassal's medical, Your Honor.
All right, and so that's 2020 CO 14AW, and I don't have the public defender on that case, so I'm going to appoint the public defender for Mr. Vassal. And Ms. Felter, did you want to enter a plea of not guilty?
Yes, Your Honor.
Okay.
Division 63, pretrial conference, September 24th at 8:30 a.m., courtroom 12C.
Okay, did you say Wilkerson?
No, Wilkerson is medical as well, Your Honor.
Okay, and that's 2020 MM 6765AO. The PD was previously appointed. It was transferred from a felony to a misdemeanor battery, and he said medical. So, Ms. Felter, did you want to enter a plea of not guilty?
Yes, Your Honor.
Division 62, pretrial conference, October 1st at 9 o'clock, courtroom 9B.
And then when?
When is medical, Your Honor?
Okay, 2020 MM 6768AO. The PD was previously appointed. It was transferred from a felony to a misdemeanor. And so, Ms. Felter, did you want to enter a plea of not guilty?
Yes, Your Honor.
Okay.
Division 62, pretrial conference, October 1st at 9 o'clock, courtroom 9B.
All right. Come on. I think that's all we got there. Tell me your name again.
Dontavius Rozier.
Okay, I had, what are we, oh, these are the add-ons. Okay. All right. Dontavius Rozier.
Yes, ma'am.
I have that as a 33-day motion. I don't know why he's here.
Not on my paper. It is scheduled as a 30-day motion on my sheet.
I'll show you what later, it's on the list.
Who put it on the list?
Downstairs gets that list, and they usually set them on here, but they didn't put do not bring over. for now.
Okay.
So I'll give you a copy.
So, Mr. Rozier, it's 2020 CF 3984AO. I believe the state did file a notice of non-filing on September 18th, 2020.
Yes, Your Honor.
Okay. So they shouldn't have brought you over. There was no reason for that, but I'm going to grant a motion that your attorney's filed. I don't know how that will affect your status in the jail. But the motion is granted, okay?
Thank you, ma'am.
And as soon as they see that, I don't know why they didn't, I'm not sure. Okay, and, all right, Mr. Jackson.
Your Honor, I'm sorry for the inconvenience,
Yeah.
but I feel like I should plead not guilty as of now.
Okay, that's fine, whatever you want to do. I don't want to force you or think that you have to do anything today. If you want to explore anything or the offer with your attorney, I think that's a great idea, okay? So, what we'll do is, I did appoint the public defender, and we'll enter a plea of not guilty, okay?
Yes,
All right, and then I think you probably have the public defender in your other cases.
Yes, ma'am.
Okay, do you have a
Is
question?
there a bond amount on this charge?
Does he, I'm sure he has a bond. What was the summons, correct?
Yes, Judge, he's not being.
So you're not held on this case,
Yes, ma'am.
okay? So, just make sure that you keep in touch with the public defender so that they know that you're in jail in case when you get a court date for it, that they know that you're not intentionally missing any court date if you're still here, okay?
Yes, ma'am.
All right.
Thank you.
Division 84, pretrial conference, October 8th at 10 o'clock a.m., courtroom 4B.
Okay, good luck, sir. morning. Are you here to see somebody?
I am here for an 11 o'clock Dayton Axum.
We don't have 11 o'clock dockets. Where are you getting that information?
I believe that courtroom 2.
Okay,
might
maybe
have-
another
Is it
courtroom.
Or is it?
I think it's courtroom 3.
So that I can tell you why I got this information. He was arrested on an out-of-county warrant last night. There was a warrant at a Seminole. And when he was arrested, he had a bond, but they put an IA hold on it. So when we contacted the jail last night, they said he would have 11 o'clock.
Yeah, I know. 11's on the weekend. So you know what number you called? Because this
The
keeps
main
happening.
jail line, I spoke with booking and information down at the mail.
You don't know who you talked with?
Sorry? No,
You don't
I
know the name?
I would be lying to you if I
No,
said-
that's
Your Honor, I
fine.
don't
I'm just
know.
trying to figure this out because this is happening a lot. And they're being told 11, and I thought I got it all situated away. Because the website says 9 o'clock or 1 o'clock.
Even downstairs, when I walked in, I said, I'm here to see Dayton Axum, he's in courtroom 1 at 11, right now.
When you say downstairs, do you mean the security officers?
Yes, ma'am, they had like a list of 4 different dockets in front of them, and they started to look at them, and they confirmed who I was here to see, and they told me to come up to courtroom 1.
And Your Honor, he is on our out-of-county.
Okay, I'm just trying to figure this out because I'd like to stop this from happening because people are being given this information repeatedly when they call the jail, so.
Yes, ma'am.
The only time that we start at 11 is on the weekends, so.
That's what I thought, because I've been here on the weekends recently
Yeah.
when you've done it at 11. It used to be 9 o'clock, but I think they moved it to 11.
Well, it's strange because we have one docket and we tend to move things around just because of how things may go during the day. Do you know what did you go to the jail website and then you called a specific number or?
Yes, ma'am. I believe that's what happened. I called the booking and release information line.
Okay.
And you get, you press some prompts and you get to an individual, and they ask you for the booking number, and then they go through in the next court hearing.
Okay, I'm just trying to narrow it down.
I understand.
No,
I'm
that's
sorry to
fine.
disrupt your docket
No,
this
you're
morning.
fine, and I think I did move up the out of counties anyway. So, did you want a moment to go talk with your client? They're not medical, are they?
Your Honor, I don't believe I need a moment. I maybe need a moment to speak to the state.
Okay.
Just to,
So what?
it's out of Seminole, he has a bond. We're prepared to post that bond, but there was an IA hold, so we just wanted to come in
And
and make sure we address that.
more than likely, the court, nothing, I can't speak for the court, but generally, we don't take action on the hold. The IA hold is because he's, yeah.
I have no idea what he said. He said, I don't know how much, we only have like 1 or 2 out of counties, right? Yeah, Seminole.
I don't know, but, so there's really not.
I'm sorry, it's really hard. Okay, let's bring him out.
Yes, ma'am. Where do you want me standing?
We just use that podium.
Okay, you want me next to him? Different courtrooms have it different ways.
Whatever you're most comfortable with, as long as you're near a microphone and I can get your,
I'll stand right next to him, sir. That's fine.
all right. And then can you state your name for me, please?
Dayton Axum.
All right, Mr. Axum, and then, can you tell me your name and your appearance?
Yes, Your Honor, my name is Alfredo Robert Zamora. I am his counsel. In both cases, I was retained last night for the Seminole County issue.
Okay.
And I represent him in his open petty theft that I believe triggered the IA hold. We have been set to resolve that through pretrial diversion. I don't know the facts of the Seminole County case, if it predates or
I don't
anything.
usually, I have no idea what happens in Seminole because I don't get the warrant. I only get like the teletype and that there was a warrant. And so I don't think I've ever taken any action on an
Okay.
out-of-county hold or on a hold on an out-of-county warrant because I have no idea what happened.
Yes, ma'am.
So for the Seminole County case, he does have the out-of-county warrant and there is a bond set at $8,000. So you'll be able to post that bond. I'm not taking any action on the add-on, it's a notice to appear. And I've gone back and forth with corrections about this issue as well because he's not out on release. It was a
Right.
notice to appear, so there really shouldn't be a hold. That's a whole other issue too. So
I
I
tried
got
to
the
have that
phone issue
conversation.
and the notice to appear issue, so
Yes, ma'am.
You've managed to touch on 2 issues that I have.
I tried to speak to the jail about that issue last night and even spoke to a sergeant, and they said that it was out of their hands. and
Yeah,
that
we're
it had
trying to
be
resolve
adjusted.
that in the admin order, but doesn't seem to be going anywhere right now, so. But, so you should be able to bond out Mr. Axum now, okay? And, just make sure you keep in touch with your attorney and don't miss any court dates, okay?
All right.
All
Donna,
right.
just for clarity, does your teletype say how many charges? And if there's like different amounts per charge?
It just says bond 8,000,
Okay.
burglary of a conveyance.
Okay, thank you,
That's
Your
all
Honor.
I have.
All right, we'll get you bonded out. We'll be out later today, okay? All right, take care. I'm gonna go the other. Judge, I have
Okay.
nothing further. May I be excused?
Yes, thank you so
Thank you,
much.
Your
I'm
Honor. Have
sorry
a good
about the
day.
misinformation.
No, have a good day.
All right, you too.
Your Honor, we have a battle.
Okay.
Please, I'm gonna help.
Okay. I don't believe that Ms. Bush would have an offer for that if we reset it anyway. It's an exposure of
Honor.
sexual organs, so I didn't, okay. Let me just. Okay, so Mr. Battle is mental health, 2020 MM 6857. I'm gonna appoint the public defender. Do you want to waive, Ms. Felter?
Yes, Your Honor.
All right, it's a warrant for exposure of sexual organs, so probable cause was previously found. He's not to return back to where the offense is alleged to have occurred, no contact with any witnesses, no alcohol or drugs without a prescription, and no firearms, weapons, or ammunition. That's everything that was on Judge Wilson's warrant. And the bond will stay at $750. And my pen died. All right, good morning. Tell me your name.
Raymond Belshner.
All right, Mr. Belshner, you're here. Looks like in case number 2020 MM 467AA, arrested for trespassing in a structure or conveyance. I do find that there's probable cause. I have a form for the public defender, but before I appoint them, Ms. Bush, did you have an offer?
Yes, Your Honor. It's an adjudication of guilt, 7 days Orange County Jail, 2 days credit time served, no return to the Wawa on Edgewater Drive in Orlando, no contact with witnesses, abide by all trespass warnings and court costs.
All right, so Mr. Belshner, did you want to accept that offer?
I can't hear you, ma'am.
Okay, I'll tell you what the offer was. It's an adjudication of guilt, 7 days with credit for the 2 days that you've served, and no return back to the Wawa, no contact with any victims or witnesses, and abide by the trespass warning, and I'll give you a year to pay your court costs off.
So, I still don't understand what you're telling me. Don't go back to the store?
Okay. Can you not hear me?
I can't hear. I got
Okay,
bad ears.
Let's get him some headphones, and we'll.
Thank you. Okay.
All right, can you hear me now, Mr. Belshner?
Yes.
Is that better?
Much
Okay.
better.
So the state's offer is an adjudication of guilt, 7 days with credit for 2 days time served, so you'd have to spend a couple more days here at the jail. You can't go back to the Wawa, you can't have any contact with any witnesses or victims, and you have to abide by the trespass warning. And I'll give you a year to pay your court costs off. So if you want to accept the offer today, you can do that. If you don't, then you don't have to.
How about you just let me go and I won't go back to the store?
Okay, well, that's not how this works. So that's the state's offer. If you don't want to accept it, you don't have to.
So how much more time do I have to do here then?
I can't tell you exactly that, but you've served 2 days and you have 7 days, so I think that would get you out today, Monday. Friday? I don't know. My best guess?
Yeah, if I get to do a couple days, I guess I'll have to.
Well, you don't have to. You don't have to accept the offer if you don't want to. But if you want to resolve the case today, that's the offer.
Okay, I'll do a couple more days.
Okay. Did you read the plea form?
This one here? Yeah, I got a copy of it.
Okay. Did you understand everything on the plea form?
Yes,
Do you understand all those rights that you're giving up by entering the plea?
yep,
Are you on probation?
no,
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
okay, I'm a citizen.
Okay. Do you understand everything that we discussed about the plea offer?
Yes,
Okay.
I'm gonna have to do a couple more days.
Okay. And you can't go back there, abide by the trespass warning, right?
That's fine.
Okay. I find a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 7 days with credit for 2 days' time served. You may not return back to the Wawa at 5820 Edgewater Drive. No contact with victims or witnesses. Abide by the trespass warning. I'll order you pay your court costs by September 21st, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within
What-
30 days. If you cannot afford an attorney, one will be appointed for you. I'll take no action on your out on release date, case. You do have a court date coming up next month.
What's going on here?
Hey, Mr. Belschner, you have a court date coming on. You can't hear?
I don't, it's not working.
Can you hear me? Can you hear me now?
Yes, I can.
Okay. Do you need me to repeat everything?
No, just want me to do a couple more days and
Okay.
stay
I'll
away.
give you a year to pay your court costs off.
Okay,
If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. You have a court date coming up in about a month. You know that, right?
and,
Okay.
no, I didn't know that.
Okay, you have a court date coming up. You have the public defender in that case. Make sure you get in touch with them and that you don't miss any court, okay?
Okay,
All right. I'll take no action on the other case.
okay.
And I didn't appoint.
I didn't put it on there.
Okay. All right. Tell me your name, ma'am.
Natasha Fluker.
All right, Ms. Fluker, you're here in 2020 MM 6850AO. You're arrested for trespass on property after warning. I do find that there's probable cause. I don't have a form for the public defender. Do you have an offer, Ms. Bush?
I do not. This was a private residence, Your Honor.
Okay, so Ms. Fluker, the state doesn't have an offer. Do you want me to see if you qualify for the public defender?
They don't have an offer?
No, it's a victim case, so the victim has a right to be notified and discuss any offer or any resolution.
Okay.
Okay, so they're not gonna make an offer today, and I'm not gonna resolve the case without a victim having that opportunity, okay?
Okay.
Do you want me to see if you qualify for the public defender?
Sure.
Okay, do you work?
No?
Do you get any income whatsoever?
No.
Okay, and so I'm gonna see that you qualify for the public defender. What I'm gonna do is order that you're not to return back to 5 South Fanfare Avenue. You're not to have any contact with victims or witnesses and abide by the trespass warning.
Okay.
And are you living in, at the 608 Cookman Avenue? Is that a yes?
Yes.
Okay, and do you live with anyone?
My mom.
Okay. And you understand that if I release you on your own recognizance today, that you're gonna need to show up to court or whatever, if that's in person or virtually? Do you understand?
Yes.
And if you don't, then you can get a warrant and you can be held at no bond,
Okay.
okay?
Yes, ma'am.
So, what I'm gonna do is release you on your own recognizance, and I'm gonna order that you get in touch with the public defender within 24 hours of your release.
Okay.
So call the phone number so that they know how to get in touch with you, okay?
The paperwork that they give me?
Yes.
Okay.
All right?
Did we? Okay, thank you. Thank you.
All right, good luck, ma'am. All right, tell me your name.
Yes, ma'am. Christopher Gaskin.
All right, Mr. Gaskin, I think I saw you about a
Yes.
week ago.
Yes, ma'am.
All right. You're here in 2020 MM 468AA. You're arrested for trespass on property after warning, and I do find probable cause. I don't have a form for the public defender. Ms. Bush, did you have an offer?
Yes, Your Honor. And keeping in mind that Mr. Gaskin has been with us previously. However, the state's offer is an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to the 7-Eleven at 851 Lee Road in Orlando, no contact with witnesses, and abide by all trespass warnings.
All right, Mr. Gaskin, did you want to do that today?
So that mean I go home today?
Yes.
Yes, ma'am. I was just outside. Yes,
Okay.
ma'am. Yes, ma'am.
I'm just letting you know if you keep coming back, it may not be a credit for time served, okay?
I understand.
All right.
Yes, ma'am. I didn't do nothing. I was just outside.
Okay, you don't need to explain, but
Yes,
if you
ma'am.
want to accept
Thank
the
you.
offer and resolve it, it's
Yes,
a
ma'am.
credit for time served,
Yes,
okay?
Judge. Thank you.
If you want to defend the case, you're more than, that's your right, okay? All right, so did you read the plea form?
Yes, ma'am.
Did you understand everything on it?
Yes, ma'am.
Do you understand all those rights that you're giving up by entering the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
Okay, I do find a factual basis to accept your plea based on the affidavit. I will adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served.
Yes, ma'am.
No return to the 7-Eleven at 851 Lee Road. No contact with victims or witnesses, and abide by the trespass warning. I'll order you pay your court costs by September 21st, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Mr. Gaskin, I hope I don't see you again.
Yes, ma'am. You won't see me no more.
Okay.
You're
Good
really
luck.
looking out for me. I really appreciate it, Judge.
Good luck.
Thank you. Thank you.
Next person, Amy, is medical.
All right, Ms. James is medical, and is that medical?
Yes, Your Honor.
Okay. So my guess is, so I'm gonna appoint the public defender, and Ms. Felter, did you want to waive?
Yes, Your Honor.
Okay, it's 2020 MM 466AA. It's trespassing, and there is probable cause. She's not to return back to the Circle K at 1252 South Apopka Boulevard. No contact with victims or witnesses, and abide by the trespass warning. I'm gonna set the bond at $250. All right, tell me your name.
Donald Kennedy.
Mr. Kennedy, you are here in 2020 MM 818AW. It's trespass on property after warning. I do find that there's probable cause. Before I appoint the public defender, did you have an offer, Ms. Bush?
Yes, Your Honor. It's an adjudication of guilt. 5 days Orange County Jail, credit for 2 days credit time served, no contact with victim or witnesses, no return to the scene, which is the Gas and Go at 6415 West Colonial Drive. Abide by all trespass warnings and court costs.
Mr. Kennedy, did you want to accept that offer? It's
Yeah.
5 days with credit for 2 days, so you'd be here another, I think, 2 days or so, okay? You want to do that?
Yeah.
Okay, did you read the plea form?
I can't see nothing.
You can't see? Okay, so you need somebody to help you with the plea form?
I'm all right.
Huh?
It's okay.
I can't hear you.
It's okay.
Well, I know, I need to make sure that you've read and understand the plea form. So I'm gonna appoint the public defender, you filled out the affidavit, and maybe Ms. Felter, if you can go over the plea form with him, that would be great, okay?
Absolutely, Your Honor.
Or we can see if the Does that help you? Okay, then if he doesn't need the help, then I won't appoint him. All right, come on forward, sir. Tell me your name.
Ricky Andre?
Mr. Andre?
Yes, ma'am.
All right, you're here in a couple of cases. I've got 2020 CF 113828O. It's fleeing and attempting to elude a law enforcement officer with lights and sirens activated. And I do find that there's probable cause. I'll appoint the public defender to represent you in that case. You cannot drive without a valid driver's license. Your bond is set at $7,500. And then you've also got 2020 CF 113830. It said driving while license suspended is a third subsequent offender. And I do find that there's probable cause, and I'll appoint the public defender. Your bond will stay at $2,500, and you cannot drive without a valid driver's license. Based on those new law arrests, they filed on-view violations of probation in 2 cases. It looks like I've got, I don't even have a case number. They just attached.
You want me to read it into the record? Here's the order.
So 2012 CF 5285 and 2012 8413. Is that right? Okay. All right, and so they filed on-view violations of probation in those 2 cases. I do find that there's probable cause for those, and I will appoint the public defender for you in those 2 cases. You'll see Judge Whitehead on the violations of probation in a couple days. So keep in touch with the public defender on those, okay?
So, I got a hold, or I'll be able to bond up?
Well, you do have a 5-day hold, and you have no bonds on the violations of probation, so I can't give you any legal advice as to whether or not you should bond out on the cases that you have bond on, because then, you won't be getting any credit. So that's something I can't tell you, but the public defender might be able to tell you what you should or should not do. I certainly can't.
Do you have your PIN number and everything for your attorney? Okay. I'll have him contact you and talk to you about, whether to bond out on the ones that are bondable. But as Your Honor was saying, you don't get credit on that case.
So after the 5 days, I'll be able to bond out, or?
No, sir.
No,
you have
we'll
bond
deal
on
with it.
the
We'll call you.
All right, thank
We'll,
you.
we'll call you on the blue box, okay?
All right, Mr. Kennedy, are you finished reading? Okay, I'm glad that we got you those glasses. Thank you. Okay, so did you read the plea form? All right, and again, this is 2020 MM 818AW, and you're gonna enter a plea to the trespass on property after warning. Did you understand everything on the plea form?
Yeah.
Do you understand all the rights that you're giving up by entering the plea?
Yeah.
Are you on probation anywhere?
No.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Well,
Yes?
Yeah.
Okay. I do find a factual basis to accept your plea. I will adjudicate you guilty, sentence you to 5 days with credit for 2 days' time served. No return back to the 6415 West Colonial Drive. It's a business, so you're not to return back to that location or have any contact with victims or witnesses. And abide by the trespass warning. And so I'll order you pay your court costs by September 21st, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you. Good luck, sir. Okay.
Mr. Boyott, if you'll raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
yes, sir.
State your name, please. All right, Mr. Boyott, You're here this morning in two cases. In case 14 CF 2767, an admission form has been submitted by Mr. Tamarkin, which indicates you wish to admit that you willfully violated your probation. You were placed on probation in this case for escape, which is a second-degree felony, punishable by up to 15 years state prison, up to 15 years probation, and/or a fine of up to $10,000. Do you understand?
Yes, sir.
You're accused of violating that probation. It's alleged that you violated Condition 2 by failing to pay the cost of supervision as ordered, that you violated Condition 7 by unlawfully consuming cocaine. On or about March 15th of 2019, it's alleged you violated Condition 8 by failing to support your dependents to the best of your ability while on probation, that you violated Condition 10 by failing to pay the fines and court costs as ordered, that you violated Condition 1 by failing to report to the probation office for the month of April of 2019, that you violated Condition 3 by moving from your last approved residence at 1720 Mabet Street in Kissimmee on or about April 28th of 2019 without prior approval of your probation officer, and that you violated Condition 5 by committing the offense of providing false identification to a law enforcement officer on or about April 9th of 2020 here in Osceola County. Do you understand what the allegations are, sir?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to up to 15 years state prison. Do you understand?
Yes, sir.
And do you wish to admit that you violated your probation as alleged?
Yes, sir.
I've also been provided a written plea form in case 20 MM 932, which indicates that you wish to enter a plea of guilty to what says resisting without violence. The charge is actually providing false identification to a law enforcement officer.
Oh, I'm sorry, Your Honor.
To amend that. So in case 20 MM 932, you are charged with providing false identification to a law enforcement officer, which is a misdemeanor punishable by up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. Do you understand?
Yes, sir.
And how do you wish to plead to that charge?
Yes, sir.
All right. Did you read and understand the written plea form as well as the written admission forms?
Yes, sir.
Do you have any questions about anything on either form?
I didn't hear you, sir.
Sorry?
I didn't hear you.
Do you have any questions about anything on either form?
No, sir.
Are you currently under the influence of medication, other drugs, or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Has any person coerced or forced you in any way to enter this admission and this plea?
No, sir.
We had a plea conference earlier, and I heard from your attorney as well as the prosecutor. And based on the underlying facts of the escape in this case, the court, if you enter the admission, had indicated you'd be sentenced to 30 months in the Florida Department of Corrections with credit for the time that you've served. Is that your understanding of the agreement?
Yes, sir.
And the, looks like it's been whited out on the misdemeanor. What's the agreement as to the?
Your Honor, there is none. He's pleading straight up to the court. We would ask the court to impose a concurrent sentence with prison time on the felony.
Okay. You understand there is no agreement as to what the sentence would be on the misdemeanor charge?
Yes, sir.
All right. You've been represented by Mr. Tamarkin. In these cases, are you fully satisfied with his representation of you?
Yes, sir.
Do you believe it is in your best interest to enter this plea and this admission?
Yes, sir.
Do you understand that if you are not a United States citizen entering this plea, and this admission will subject you to deportation.
Yes, sir.
You have the right in the felony case to have a hearing before the court without a jury to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did, in fact, violate your probation as alleged. Do you understand?
Yes, sir.
On the misdemeanor case, the providing false identification charge, you have the right to a jury trial. If you chose to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty unless a jury unanimously found the state had proven your guilt beyond reasonable doubt. Do you understand?
Yes, sir.
At both the violation probation hearing on the felony charge and the jury trial on the misdemeanor charge, you would be entitled to be represented throughout all proceedings by your attorney. You would have the right to confront and cross-examine witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You are entitled to use of the court's subpoena power to require any witnesses you may have to be present at the trial in the new case, as well as the violation probation hearing in the older case. You also would have the right at each proceeding to testify yourself. At the jury trial on the misdemeanor charge, you would have the absolute right to choose not to testify. And if you chose not to testify, the right to have the jury instructed they could not consider that decision as evidence of guilt. At the violation probation hearing on the escape charge, you would have the right to choose not to testify with respect to the allegation you committed a new crime while on probation. You could be required to testify with respect to other alleged violations. Do you understand that you have those rights?
Yes, sir.
By entering a admission and plea of guilty in these cases, you're giving up all the rights that I've talked to you about, as well as the other rights that are written on the admission and plea forms. And there'll be no further hearing or trial in either case other than a sentencing hearing, which we will conduct this morning. You also, by entering the admission and plea, are waiving your right to appeal any matter relating to either case other than the jurisdiction of this court to hear your cases and the legality of the sentences imposed. Do you understand, sir?
Yes, sir.
Very well. All right, I find that you are alert and intelligent, that you understand the nature of the allegations and charges against you, the penalties you're facing, and the rights you're giving up by entering this admission and this plea. I find that your decision to enter the admission and the plea has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've expressed satisfaction. I've read the arrest affidavit by Officer Nieves in case 20MM932, and based on that affidavit, I find that there's a factual basis upon which your plea can be accepted in that case. So I'll accept your plea of guilty in case 20MM932, as well as the admission of violation of probation in case 14 CF2767. Mr. Tamarkin, do you agree with the score sheet, 108.1 total?
Yes, sir.
Points?
We've been through that at the time of the plea conference. Yes, sir, Judge.
And what's the time served in these two cases?
In 20MM932, 166 days, 14 CF2767, 393.
Okay. All right, is there anything further than to be said before sentences?
No, Your Honor.
You were appointed in both cases?
No, sir.
Retained?
Yes, sir.
Okay. State anything further with respect to sentence?
No, Judge.
All right, Mr. Poyat, as I indicated at the plea conference, in case 14 CF2767, the court is going to impose a downward departure sentence. I'm somewhat uncertain of the legal underpinnings for that, but I do find that due to the nature of the escape charge in this case, where you actually essentially skipped out on work release and returned on your own to the work release center. And this was a practice that apparently was okayed by at least someone at your, the place of your employment, that is a significant mitigating circumstance that's not otherwise taken into account, given the nature of the charge and the criminal punishment code score sheet. So based on that, I will enter a downward departure sentence. I will revoke and terminate your probation. You'll be sentenced to 30 months in the Florida Department of Corrections with credit for the 393 days that you have already served. You are ordered to pay the outstanding financial obligations of $3,166.85. The money is ordered to be paid through the Clerk's Collection Program at the rate of no less than $50 per month. First payment will be due by October 1st of 2022. In case 20MM 932, you'll be adjudged guilty of providing false identification to a law enforcement officer. And you'll be sentenced to 156 days in the Osceola County Jail, 166 days in the Osceola County Jail. With credit for the 166 days that you have served, you're ordered to pay a fine of $250 plus the misdemeanor work costs. That will total $535.50. This money is ordered to be paid through the Clerk's Collection Program at the rate of no less than $50 per month consecutive to the payment, so we're ordered in case 14 CF 2767. Is there anything further with respect to this?
Nothing further, Your Honor.
Mr. Poilot, you have 30 days within which you can appeal the judgment and sentence was just entered. If you wish to appeal and cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days, you waive your right to appeal. Do you understand?
Yes, sir.
All right, thank you. I don't know if the state's intending to appeal this or not, but we'll see where it goes. All right, we have Mr. Keeley present. That's set for 10, but if you're ready to proceed.
I'm ready. I'm just standby counsel, Judge.
Thank you, Mr.
I did
Poilot.
bring my computer because I have a link to that, but I just assume do it now in the courtroom if the court's prepared.
He has also 2 cases of mine that he is playing to.
Okay. Good. Ridge Akile? Morning, sir. If you'll please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Okay. State your name, please. Okay, Mr. Akile has 2 cases with Regional Conflict Council, and those are going to be resolved this morning. You have a plea for?
I don't
Judge, I think this might be a statewide case. I just want to make sure if there is one statewide, but there's two or not. Just trying to see if they're here, appearing remotely or not.
Oh, we have no one from statewide. Which case was the statewide case?
The 495. The one Mr. Tamarkin is here by.
Okay, well, that one's, actually, Mr. Markin, I don't think we'll be able to do it until 10 o'clock because statewide was given notice for 10. So, Mr. Keeley, we're going to take care of two of your cases at this time, and we'll see you again at 10 o'clock for the case that you have Mr. Tamarkin as standby counsel for that's with the statewide prosecutor. All right? All right. Mr. Keeley, let me pull these cases up. Okay. You've written the same case number on both.
I did.
Yeah, so.
One with 2 counts and the other one with.
With your permission, I'll change the case number on the case with the multiple counts
Thank you.
to 18 CF 2593. All right. Mr. Keeley, in case 18 CF 2593, a written plea form is submitted which indicates you wish to enter pleas of guilty to fraudulent use of personal identification information as charged in count 2. Fraudulent use of personal identification information as charged in count 3. Possession of an unauthorized driver's license as charged in count 4. Possession of an unauthorized driver's license is charged in count 5, and resisting an officer without violence is charged in count 6. Is that what you wish to do in that case, sir?
Yes, Your Honor.
All right, and say you'd be in all process in count 1.
Your Honor, this case is assigned to ASA Melinda Merced. I tried emailing her. I haven't heard back yet from her. I believe this case is not scheduled until 10 a.m. I don't know if she's on the team yet.
As an officer of the court, I can say that we had a conversation. She's Kennedy County. Dismissing count 1.
Well,
But if we have to wait, we have to wait.
I guess we'll have to wait if
All right.
we can't ever.
Hold that up there. You want me to?
All right. Mr. Keeley, I'm afraid we have to wait for the prosecutor in the case just to verify that that count will be dropped. So if you'll just have a seat, we'll call you back as soon as we can. Thank you. Okay. Daniel Doty was scheduled as a plea. Is that going to be a plea this morning?
Mr. King is covering it at the jail, but yes. Good morning, Your Honor. Ben King here with Mr. Doty. I have a completed plea form by him. It's just not been signed by the prosecutor yet.
Okay, it's there and not here.
I gave, the state's on Teams, but I gave Madam Clerk the offer. It's adjudication of guilt, 10 months jail, court costs.
We have a signed plea form the defendant has signed.
It's at the jail with Mr. King.
Can we get that here? You email a copy? I don't like doing a plea on a felony without the plea form here.
Yes, Your Honor. I can drive over to the courthouse right now and bring you the plea.
I don't have, he has it. He got it signed.
Yeah, there were some issues this weekend getting around the jail in here.
There's no internet at the jail, so there was issues getting it signed, so he went this morning, and I told him I would tell the clerk the offer since he didn't think he would have enough time to get back here.
Oh, I can email it.
Yeah, if you can email it, I guess.
Step out to my car, email it, and then step back in here.
Okay, so, did you have anything else, Mr. King, that you have paperwork on here?
Not from the jail, Your Honor, unless anyone needs to fill out a public defender application.
Okay.
Yeah.
We'll pass, Mr. Doty.
Okay. I'll step out to the car, email this to you guys.
Thank you, sir.
Yeah, thank you.
All right, we have Christopher Garrett.
Good morning, Your Honor. Ernie Mullins on behalf of Christopher Garrett. Mr. Garrett is here for an out-of-county plea. I'm hoping that the plea form's in the court file. If not, I got it right here.
Oh, I've got it. Okay, Ms. Garrett, if you'll please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? State your name, please. All right, Mr. Garrett, you're here this morning in Polk County case 20MM 764. And a plea form has been submitted in this case that indicates you wish to resolve the case by entering a plea of guilty to battery as charged in count 1 of the information. Is that what you want to do?
Actually, Judge, I didn't. There are 2 more counts, and he's pleading to each of those as well.
On the plea form, Mr.
That's what I was just about to say, Judge.
Add them to the plea form, please.
Yeah. Battery, resisting.
Criminal mischief is count 2. Criminal mischief is count 2.
Yeah. Battery, criminal mischief, resisting.
And you said criminal mischief, right? Criminal mischief and resisting. I'm sorry about that. We talked about that he's playing all 3. He knows that.
All right, Mr. Garrett, I've been informed that you wish to enter pleas of guilty to battery as charged in count 1, criminal mischief with damage of more than $200 as charged in count 2, and resisting an officer without violence as charged in count 3. Is that what you want to do?
Yes, Your Honor.
Each of those 3 charges is a misdemeanor, which is punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand?
Yes, sir.
Did you read and fully understand this written plea form?
Yes, Your Honor.
Do you have any questions about anything on the written plea form?
No, sir.
Are you currently under the influence of any type of medication or other drugs or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Did any person coerce or force you in any way to enter this plea?
No, sir.
Your recommendation is that you would be adjudicated guilty of all 3 counts, and that you be sentenced to 120 days in the county jail with credit for the 30 days that you've served. You'd be required to pay a $100 cost of prosecution, cost of investigation of $286, and I can't make out 8 cents.
I think it's just $286.
$286, okay.
Yeah, I just underlined the
It's
zero.
$286.96 to the Polk County Sheriff's Office.
I had a zero.
So it'd be cost of investigation of $286.96, or 98 cents, 96 cents. Is that your understanding of the agreement?
Yes, sir.
Are you satisfied with your lawyer in this case?
Yes, sir.
Do you believe it is in your best interest to enter this plea?
Yes, sir.
Do you understand that if you are not a United States citizen, entering this plea will subject you to deportation?
Yes, sir.
You have the right to have a jury trial. If you elected to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond and to the exclusion of every reasonable doubt. You'd have the right to be represented throughout your trial by Mr. Mullins. You would have the right to confront and cross-examine any witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You are entitled to have the court order any witnesses you had to be present at the trial so you can present their testimony to the jury. You also have the right at trial to testify yourself, or you could choose not to testify. If you elected not to testify at trial, you have the right to have the jury instructed they could not consider the decision not to testify as evidence of guilt. Do you understand that you have those rights?
Yes, sir.
By entering a plea of guilty, you're giving up the rights that we've just talked about, as well as the other rights that are written on the plea form, and there won't be a trial in your case. You also, by entering the plea, are waiving your right to appeal any matters relating to your case, with the exception of this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes, sir.
All right. Mr. Garrett, I've read the arrest affidavit by Deputy Leonard in the court file. And based on that affidavit, I find that there's a factual basis upon which your plea can be accepted. I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties you're facing, and you understand the rights that you're giving up by entering this plea. I find that your decision to enter the plea has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've told me you're satisfied. Now, you do understand, Mr. Garrett, that you have the right to have this case heard in Polk County by a Polk County judge. By entering a plea here today, you're waiving jurisdiction and venue, so you're agreeing that this court hear your case and accept your plea and impose sentence. Do you understand that?
Yes, sir.
All right. And is that what you want to do?
Yes, sir.
All right. So for the reasons I've announced, I will accept your plea of guilty. Is there anything further to be said before sentence is imposed?
Your Honor, as to the credit for time served, the judge in Polk County signed the order revoking Mr. Garrett's bond on the 20th of August, and today's the 21st of September, so with the day that he did originally, that would be 33 days.
I have the order of the revocation of bond on the 25th, that's my opinion. I have this order here. It was the 25th of August.
26th?
25th.
25th?
So he originally had 2 days, he bonded out, then the bond was revoked on the 25th.
Mine says the 20th.
That's what the order says.
The 20th or 25th?
Says the 20th.
Okay. Oh, I saw 5. Sorry, my bad.
Okay.
He has extra days.
So,
Don't have actually. I have extra days, so it'll be 35 actually.
30, 35?
33? Yeah.
35.
Oh, 35, better still. I like your arithmetic better than mine, Judge. Thank you.
All right. Ms. Garrett, at this time, you'll be adjudged guilty of battery as charged in count 1 Criminal mischief with damage of $200 or more is charged in count 2, and resisting an officer without violence is charged in count 3. As to each count, you'll be sentenced to 120 days in the county jail with credit for 35 days that you've already served. Those sentences will run concurrent with each other. You are ordered to pay cost of prosecution of $100, cost of investigation of $286.96 to the Polk County Sheriff's Office. I'm going to go ahead and impose court costs of $273. And there is a required court cost of $201 pursuant to Florida Statute 938.08 and $151 pursuant to Florida Statute 938.085. I think I'm required to impose, I won't impose a fine since that wasn't part of the agreement. Mr. Garrett, you're ordered to pay the money that's owed to the clerk of court in Polk County, Florida. I will order that you contact the clerk within 30 days of your release from the county jail and arrange a payment schedule to make those payments. All right, is there anything further?
Nothing further, Your Honor, thank
Mr.
you.
Garrett, you have 30 days within which you can appeal the judgment and sentence was just entered. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand? Yes, sir. Thank you, sir. Good luck to you. All right, we ready on Mr. Guivas?
Yes, Judge. Your Honor, myself and an associate of mine went to go see Mr. Guivas on Friday morning, at which point he was very upset and he went back to his pod. I left this on and he basically said he wasn't going to take it.
He needs an interpreter.
Yeah, yes.
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish for Interpreter. The interpreter has been sworn in already today.
All right, good morning, Mr. Morales. We're here at this time in, excuse me, in case 19 CF 3652, State versus Jorge Andres Guivas Jorge. Mr. Jorge, if you'll please raise your right hand.
Señor Jorge, levante la mano derecha, por favor.
You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Jura solemnemente o promete que el testimonio que harás será la verdad, toda la verdad y solamente la verdad?
Sí, lo juro.
Yes, I swear.
All right. Tell us your name, please.
¿Cómo se llama usted?
Jorge Andrés Guivas Jorge.
Jorge Andrés Guivas Jorge.
Okay, Mr. Guivas Jorge, you're here this morning in case 19 CF 3652. This had been set for a plea this morning. Mr. Zaleski was just telling us where we stand, so.
Your Honor, like I was saying, I went to the jail with an interpreter on Friday morning.
Okay, if you'll,
At which point-
you'll let the interpreter get caught up.
Okay, I'm sorry, Your Honor, but the interpreter's having a hard time hearing counsel.
On Friday morning, I went to the jail with an associate to go visit Mr. Jorge, Guivas Jorge.
Sí, el caso de hoy había sido programado para una declaración. El abogado Zaleski nos está dando una actualización, un informe, y nos deja saber que el viernes fue a la cárcel con un asociado para visitar al señor Jorge.
At that point, Judge, we had probably a 20-minute, 30-minute conversation regarding the entire plea and regarding the 10-year minimum mandatory on certain counts.
Counsel, I'm sorry, did you say you had about a 20-minute conversation regarding the plea and regarding the minimum mandatory on certain counts?
That's correct.
Y entonces tuvimos una conversación como de unos 20 minutos sobre una oferta declaratoria o lo que sería declararse el caso hablando sobre las sentencias mínimas obligatorias relacionadas a ciertos cargos.
At that point, Mr. Guivas became agitated and he decided that, he said, no, I don't want to take the deal, and he went back to his pod.
Okay. I'm not sure what's going on, but counsel sounds very far away, so the interpreter's struggling.
He said at that time, Mr. Guivas became upset and informed Mr. Zaleski that he did not wish to accept or enter the plea, and he returned to his pod at the jail.
Okay, thank you, Your Honor.
The reason-
Y
I'm sorry.
en ese momento, entonces, el señor Jorge, pues, se puso un poco alterado, agitado, no quiso aceptar la oferta y se regresó a su celda.
The reason we're here today, Judge, is because maybe over the weekend he decided that he did want to accept this plea, and that's, if he wants to, then I have the signed plea form here, or if he does not, then we will prepare for trial.
La razón que estamos aquí el día de hoy, su señoría, es porque, bueno, en algún momento durante el fin de semana, si no quiso aceptar la declaración, no había querido aceptar la declaración, pero si ahora la quiere aceptar, tengo un formulario declaratorio de él aquí.
All right, Mr. Guivas Jorge, based on what Mr. Zaleski has told the court, I simply need to know this morning whether you wish to accept the plea that was negotiated on your behalf, or whether you wish to exercise your right to a trial in this case.
Bueno, señor Jorge, basado en lo que me acaba de decir el abogado, su abogado Zaleski, lo que necesito saber es si usted quiere aceptar la oferta que fue negociada para resolver el caso o si quiere ejercer su derecho de llevar el caso a juicio.
Bueno, yo hablé con mi abogado y yo simplemente le hice una pregunta que es la misma que le voy a hacer al juez, y de esta pregunta pues yo tomaré mi decisión en este momento. Yo entiendo que el plea, el juez dijo que no va a bajar de 10 mínimo mandatorio, pero él se va a basar en una investigación que se va a hacer en base a lo que fue mi vida antes del incidente. La única pregunta que yo tengo, el 10 mínimo mandatorio, ¿sería día por día, o sea, 100% la sentencia?
Well, I spoke to my attorney and I asked him a question, which is the same question I'm about to ask the judge, and based on the answer, I'm going to make a decision. So the judge said regarding the plea that there would be a 10-year minimum mandatory sentence, but that's based on investigation that would be done regarding things in my past life or what my life was before. What I would like to know is that 10-year minimum mandatory sentence, is that day for day, meaning I would serve 100% of that sentence?
The 10-year mandatory minimum is a firearm mandatory minimum that the law would require to be served day for day.
Bueno, la sentencia de 10 años como una sentencia mínima obligatoria es relacionada con un arma de fuego, es impuesta por la ley que se tiene que imponer y se tiene que cumplir día por día.
Pues solamente tengo que decir dos cosas. Lamento lo sucedido, pero no acepto el plea, y en la vez anterior, si recuerda que traté de cambiar de abogado, usted me dijo que si no me sentía conforme, usted no me iba a poder cambiar el abogado. Le pido entonces que me permita representarme por mí mismo. Gracias.
Well, then I only have two things to say. That, well, what I regret what happened, but I will not accept the plea. And last time we spoke about getting a different attorney, you said you would not change or give me a different attorney if I was not satisfied. So I would just ask then for you to allow me to represent myself.
Well, You can choose to represent yourself if you wish, but I have to have a conversation with you about that.
Judge, before we get...
Bueno, usted puede elegir representarse a sí mismo si lo desea, pero yo tendría que tener una conversación con usted sobre eso.
No hay problema.
No problem.
Before we get to that, Your Honor, I would like to create a record as to the defendant's present situation, may I? Your Honor, the defendant is here today for a potential plea to a offer from the bench.
Bueno, su señoría, me gustaría poner algo en actas con relación al acusado sobre su situación actual, si me lo permite. El acusado se encuentra aquí para una posible declaración a una oferta que se recibió directamente del
My
juez.
understanding of the court's offer is that the court would institute a cap on the sentence at 20 years in the Department of Corrections.
Y lo que tengo entendido de esa oferta es que el juez le pondría un límite a la sentencia que es de 20 años en el Departamento de Correccionales.
The court would consider a downward departure below the score sheet minimum.
Below the score sheet minimum.
Correct.
Okay. Y el juez contemplaría imponer una sentencia debajo de las pautas mínimas o irse por debajo de eso y debajo de lo que sería la hoja de puntuación.
The offer would not go, or the court would not go below the 10-year firearm minimum mandatory day-for-day sentence.
Y el juez no iría por debajo de la sentencia mínima obligatoria de 10 años día por día.
This is not the state of Florida's offer.
Esta oferta no es de la Fiscalía.
The state maintains that no less than 25 years in the Department of Corrections is appropriate in this matter.
La postura de la Fiscalía sigue siendo de que la sentencia en el Departamento de Correccionales no debería ser menos de 25 años, que eso sería apropiado en este caso.
The state also has the understanding that the current judge in this case, Judge John Morgan, is set to either retire or otherwise leave this division in the coming months.
Además, la Fiscalía tiene entendido de que el juez que está actualmente, al que está asignado este caso, que es el juez John Morgan, está a punto de jubilarse o de dejar esta división en los próximos meses.
I do not know if a subsequent judge in this division would re-extend the offer that Judge Morgan has extended in this matter, and I would continue to seek no less than 25 years in this matter.
Y yo no sé si el siguiente juez extendería la misma oferta que ha extendido el juez Morgan en este caso, pero yo seguiría pidiendo una sentencia de no mínimo, o la Fiscalía seguiría pidiendo una sentencia de no menos de 25 años.
That's the end of the record I wanted to create.
Y ese es el fin de lo que quería poner en actas.
All right, you understand that, Mr. Guivas Jorge?
¿Entendió eso, señor Guiva Jorge?
Entiendo que sí.
I understand, yes.
Okay, and the state is absolutely correct that I will be leaving the bench on December 31st.
Y la Fiscalía tiene razón en que yo voy a dejar el estrado el 31 de diciembre.
And a new judge, Judge Young, will take over this division.
Y un nuevo juez, el juez Young, asumirá el cargo de esta división.
And he very well may see the case differently and may not agree to the cap that the court had indicated it would imposed in this case.
Y ese juez muy bien pudiera ver el caso de una manera diferente y quizás no esté de acuerdo con el límite que este juez ha indicado en este caso.
Okay, Mr. Cuevas Jorge, you do have the right to elect to represent yourself in this case, but again, there are some things I need to address with you.
Sí, señor Jorge, usted tiene el derecho a escoger, a representarse a sí mismo, pero hay ciertas cosas que tengo que tratar con usted.
I need to first explain to you some of the ways that having a lawyer represent you can be to your advantage.
Primero tengo que explicarle algunas cosas algunas razones por las cuales tener un abogado que lo represente le sería ventajoso.
The lawyer has the experience and knowledge of the entire trial process. Do you understand?
Un abogado tiene el conocimiento de todo el proceso y capacidad sobre ese proceso. ¿Entiende eso?
Sí, lo entiendo.
Yes, I understand.
A lawyer can call witnesses on your behalf, question witnesses against you, and present evidence on your behalf at trial. Do you understand?
Un abogado podría convocar testigos a favor suyo, contrainterrogar a los testigos que se presenten en contra de usted, presentar pruebas a favor suyo en un juicio. ¿Entiende eso?
Sí, lo entiendo.
Yes, I understand.
A lawyer will question potential jurors during jury selection, and the lawyer has experience to know which jurors might be in your best interest to keep on the jury, as well as those who might be in your best interest to exclude from the jury.
Además, un abogado le haría preguntas a los candidatos para formar parte del jurado y el abogado tendría la experiencia para saber a quiénes le convendría a usted, con quiénes le convendría quedarse y a quiénes le convendría excluir como miembros del jurado.
A lawyer can advise you of the potential harm and consequences of what you might say in court, and can advise you as to what you have a right not to say.
Además, un abogado podría aconsejarlo o asesorarlo sobre el posible daño de lo que usted pudiera declarar o testificar en un juicio, o le podría informar sobre su derecho a lo que no tiene que decir en un juicio.
A lawyer has knowledge of the rules of evidence and knows what questions can and cannot be properly asked at trial, and will object to those questions that may be improper.
Además, un abogado tiene conocimiento o capacidad sobre las reglas o pautas que gobiernan las evidencias o las pruebas y podría hacer... I'm sorry, the interpreter just needs 1 second.
I'm sorry?
Sí, el abogado podría hacer preguntas que son apropiadas o podría protestar a preguntas que sean indebidas o impropias.
A lawyer also has studied the rules of evidence and knows what types of evidence can or cannot be properly admitted in your trial, and would be prepared to object to evidence that would not be admissible under the rules.
Además, un abogado ha estudiado lo que son las pautas que gobiernan las evidencias y sabría cuáles de estas pruebas pueden ser admitidas y cuáles no, y podría protestar a las pruebas que se quieran presentar que no sean admisibles.
The lawyer will also argue for your side during the entire trial and is in a position to present the best legal arguments for your defense.
Además, un abogado estaría preparado para discutir o presentar alegatos a su favor durante todo el juicio y presentar los mejores alegatos legales a favor suyo.
Do you understand all of that?
¿Ha entendido todo eso?
Sí, lo entiendo.
Yes, I understand.
As it is almost always unwise to represent yourself in court, I need to discuss with you a few of the potential disadvantages of choosing to represent yourself.
Como casi siempre casi siempre no es lo sabio el representarse a sí mismo, tengo que hablar con usted sobre las desventajas de pedir representarse a sí mismo.
You understand that if you choose to represent yourself, you will not receive any special treatment from the court because you are representing yourself.
Debe entender que si se representa a sí mismo no va a recibir ningún tratamiento especial por parte del juez porque usted se esté representando a sí mismo.
You understand?
¿Entiende?
Sí, entiendo, pero ahora mismo yo espero que el juez entienda mi frustración de que yo no tengo un abogado que yo entienda que es no tengo una relación con mi abogado, no me siento a gusto con mi abogado. Y si yo no me siento y que tengo una relación con mi abogado, la persona que a mí me representa es supuesta a tener una relación conmigo y yo llegar a una negociación con él. Y es algo que no he tenido con el señor Zaleski. Se lo dije la primera vez y para yo sentirme mal y que yo me sienta que se puede hacer más en mi caso, en el momento de yo defenderme, oye, para que lo haga alguien mediocre inectamente, prefiero hacerlo yo que tener la representación que estoy teniendo en este momento.
Well, I understand that, but I would like for the judge to understand my frustration because I don't have any kind of relationship with my attorney. I would need to have any kind of some kind of understanding relationship with my attorney, and I just don't feel that way. I would need that in order to have someone represent me, and then so we could negotiate a deal. But I just don't feel that way with Mr. Zaleski. And for me, then to just not feel well during my trial, or for more to be accomplished during my trial or on my behalf, or for someone to have to do it either mediocrely or not capably, then I would rather do it myself than have the representation I'm having right now.
I understand that, Mr. Cuevas Jorge, and I'm not in any way suggesting that you not choose to represent yourself.
Entiendo lo que usted dice, señor Hueva Jorge. Yo no estoy de ninguna manera tratando de insinuarle que no deba representarse a sí mismo.
The law requires me to have this conversation with you to make sure that you understand the potential pitfalls that come with making that choice.
Es que la ley me exige a mí tener esa conversación con usted para que usted entienda cuáles son los posibles traspiés o tropiezos que pudiera tener al tomar esa decisión.
But at the end of the day, it's absolutely your choice to make.
Pero al fin de cuentas, el que toma esa decisión, el que tiene que tomar esa decisión es usted.
We'd already had a discussion about your representation in this case, and the court found that you were receiving effective representation from your lawyer, although I understand you personally do not or may not get along with Mr. Zaleski.
Ya hablamos sobre el tema de la representación en el caso suyo. Ya el juez determinó de que usted sí está recibiendo una representación capaz o eficaz, aunque entiendo que usted quizás en lo personal no se lleve bien con el señor Zaleski.
And the primary difficulty you have with your attorney is that he has not been able to negotiate a plea agreement that calls for less time than what the plea offer is at this point.
Y entiendo que la dificultad principal con su abogado es que no ha podido negociar una oferta declaratoria que sea de menos tiempo de lo que ha sido la oferta hasta ahora.
If you elect to exercise your right to a trial, Mr. Zaleski is a professional and will represent you to the best of his ability.
si usted decidiese llevar el caso a juicio, el abogado Zelensky es un profesional y lo representaría a usted lo mejor según sus capacidades.
And if you choose to represent yourself, that's fine. That's your choice. I just need to finish having this discussion with you before you finalize that decision.
Y si usted decide representarse a sí mismo, esa decisión pues es suya. Simplemente tengo que terminar de tener esta conversación con usted antes de que usted tome una decisión definitiva.
Do you understand that if you represent yourself, you are required to follow all of the procedural and substantive rules of criminal law, which are the same laws which take lawyers years to learn and abide by?
¿Comprende usted de que si usted se representa a sí mismo, usted estaría obligado a seguir los mismos procedimientos y pautas que gobiernan las leyes en un tribunal penal, que tienen que seguir todos los abogados a los que les ha tomado años para aprender y entender?
Sí.
Yes.
Since you are in custody, you're also significantly limited in the resources that are available to you. A lawyer has less restrictions in access to materials and researching your case. Do you understand?
Y ya que usted pues está bajo custodia, está encarcelado, sus recursos son limitados. Los recursos que están disponibles a usted son limitados en comparación con un abogado que puede hacer más investigación, no está tan restringido como usted.
Sí, entiendo eso.
Yes, I understand that.
Your access to the state attorney or the prosecutor in this case will be significantly more restricted than the access Mr. Zaleski would have in contacting him. Any communication you have with the prosecutor has to be on record. Do you understand?
Y el acceso que usted tendría o el acercamiento que podría tener al fiscal estaría mucho más limitado en comparación al abogado Zaleski, porque cualquier comunicación que usted tenga con el fiscal tendría que ser siempre en actas.
Entiendo.
I understand.
All right, if you choose to represent yourself, the state, of course, will not go any easier on you or give you any special treatment because you've chosen to represent yourself. They will continue to prosecute the case and will be using an experienced lawyer in doing so. Do you understand?
Además, si usted decide representarse a sí mismo, la fiscalía no lo va a tomar más suave con usted, no le va a dar ningún tratamiento especial porque usted ha decidido representarse a sí mismo. Ellos seguirán enjuiciando el caso y utilizando un abogado experimentado. ¿Entiende eso?
Lo entiendo.
I understand.
All right. Also, if you were to become disruptive in the courtroom, that the court could terminate your self-representation and remove you from the courtroom, in which case the trial would go on without you being present. While I don't expect that to occur, do you understand that that is a possibility?
Just one second, Your Honor. I'm sorry.
Yes, sir.
Y además, si usted llegara a comportarse de una manera, pues, que empieza a hacer un alboroto en el juzgado, el juez podría ponerle fin al hecho de que usted se siga representando a sí mismo, se le podría sacar de la sala o del juicio y el juicio continuaría sin su presencia, aunque no me imagino que eso va a suceder, pero entiende usted que eso, pues, es una posibilidad.
Sí, entiendo.
Yes, I understand.
Also, of course, if you are convicted at trial, if you are represented by a lawyer who has made mistakes that affect the validity of the conviction. You could appeal based on ineffective assistance of counsel. If you represent yourself, you cannot claim that, on appeal, that you were ineffective in representing yourself. You understand?
Además, si usted se le condena en el juicio, si usted lo representa a un abogado y ese abogado comete errores, usted podría presentar una apelación en contra de esa condena, alegando o afirmando que la representación que recibió el abogado no fue eficaz o efectiva. Mientras que si usted se representa a sí mismo, si se le condena, usted no podría apelar afirmando de que usted no se representó eficazmente a usted mismo. ¿Entiende eso?
Sí, lo entiendo.
Yes, I understand.
All right, and we had this discussion, at least to some extent previously, but you understand that you are charged with 5 counts in this case.
Y tuvimos esta conversación hasta cierto grado anteriormente, pero usted entiende de que hay 5 acusaciones en contra de usted.
Sí, yo entiendo que hay 5 acusaciones en mi contra.
Yes, I understand that there's 5 charges against me.
And 3 of those charges carry a maximum sentence of life in prison. 4 of the charges carry a mandatory minimum sentence of 10 years if you are found guilty as charged. You understand?
Y usted entiende que 3 de esas acusaciones, la sentencia máxima puede ser de hasta cadena perpetua, y en 4 de esas acusaciones hay una sentencia mínima obligatoria de 10 años si es que se determinara que usted es culpable. ¿Entiende eso?
Sí, lo entiendo.
Yes, I understand.
All right. A couple of other questions I need to ask. You speak some English, but Spanish is your primary language, is that correct?
Y otras preguntas que le tengo que hacer, usted habla un poco de inglés, pero su lenguaje materno principal es el español, ¿verdad?
Correcto.
Correct.
And you read and write in Spanish, but do not read and write in English, is that correct?
Así que usted lee y escribe el español, pero no lee y escribe el inglés, ¿es correcto?
Correcto.
Correct.
All right. The court, of course, will provide an interpreter for you during all court proceedings, but much of the paperwork would be in English and would have to be interpreted for you. Do you understand that?
Por supuesto, el tribunal le brindaría un intérprete al español para todos los procesos, pero todos los documentos estarían en inglés y haría falta que sean traducidos. ¿Entiende eso?
Sí, lo entiendo.
Yes, I understand.
How far did you go in school, sir?
¿Hasta dónde llegaron sus estudios?
Yo terminé en 12.
I finished 12th.
Are you currently under the influence of any medication or other drugs or alcohol?
¿En este momento o actualmente se encuentra usted bajo los efectos de alcohol, drogas o medicamentos?
No.
No.
Have you ever been diagnosed and treated for a mental illness?
¿Se le ha diagnosticado alguna vez o ha recibido tratamiento alguna vez por alguna enfermedad mental?
No.
No.
Has anyone told you not to use a lawyer?
¿Hay alguien que le ha dicho que no emplee o use un abogado?
No, no hay nadie que me diga que no use ni emplee un abogado, pero actualmente no tengo la capacidad económica para contratar un abogado y entiendo que la representación que tengo no es la adecuada.
No, no one has told me not to use or employ an attorney, but at the moment my financial situation does not allow me to hire an attorney, and my belief is that the current representation that I have is not adequate.
Fair enough. Have you ever represented yourself in a trial in the past?
¿Alguna vez se ha representado a usted mismo en juicio?
No, esta es mi primera vez que tengo problemas ante la ley.
No, this is the first time that I have problems with the law.
Okay. You understand the potential dangers and disadvantages of choosing to represent yourself in court that I've just discussed with you.
¿Ha entendido o entiende usted los posibles peligros y desventajas que habría al representarse usted mismo que yo le durante un juicio que yo le expliqué?
Sí, entiendo todos los riesgos que tengo, pero volvemos a lo mismo. Entiendo que la representación que tengo en este momento no me ayuda para nada. Entiendo que por mí mismo tendría más ventaja.
Yes, I understand all the risks involved if I represent myself, but we are back to square one, where my belief is that I'm not getting any kind of assistance or help from my current attorney, and I think that if I represented myself, then I would be better off.
Well, again, that's your decision to make. You do qualify for court-appointed counsel, and you have court-appointed counsel at this time. If you wish to fire Mr. Zaleski, you may do so. But as I said earlier, I cannot appoint a different lawyer to represent you. You understand?
Bueno, esa decisión es suya, como ya lo mencionamos. Usted tiene el derecho a que el juez le nombre un abogado y usted ya tiene un abogado nombrado por el juez. Si usted quiere despedir o votar al abogado Zaleski, usted lo puede hacer, pero yo no le puedo nombrar a un abogado diferente. ¿Entiende eso?
Por eso mismo entiendo la situación, ya que él no me ha querido nombrar uno y yo no me puedo quedar sin representación ante la ley, pues tomo la decisión de representarme yo mismo en lo que hago los arreglos pertinentes para poder costear un abogado.
Yes, and that's precisely because I understand the situation that I'm in, and because I know that he cannot appoint a different lawyer or another lawyer, then that's why I am choosing to represent myself until I can make all the arrangements necessary, or I can hire an attorney.
All right. Mr. Guivas Jorge, the court also can, if you wish, appoint Mr. Zaleski to remain as standby counsel.
Bueno, señor Jorge, el juez también podría, si usted así lo decidiera, dejar al abogado Zaleski que mantenga, que lo siga representando simplemente como en calidad de al lado, a la espera, si usted lo desea.
If I were to do that, Mr. Zaleski would not take any affirmative actions in representing you, but he would be available during court proceedings to answer any legal questions you may have.
Si se hiciera eso, entonces el abogado Zaleski no estaría tomando ninguna acciones definitivas sobre su caso, simplemente estaría disponible durante cualquier proceso en la corte o en el tribunal para contestarle preguntas legales que pudiera tener.
Estoy de acuerdo.
I agree.
All right, then, Mr. Guivas Jorge, I do find that you are competent and capable of making a rational decision, and you've announced to me that your decision is to represent yourself in this case.
Bien, señor Guivas Jorge, determino que usted está en sus facultades, que tiene la capacidad de tomar decisiones racionales y que usted nos ha comunicado, dicho que su decisión, es de representarse a sí mismo.
Well, at this time, relieve Mr. Zaleski of duties as attorney of record in this case.
Bien, entonces lo que vamos a hacer en este momento, I'm sorry, Your Honor.
I'm relieving Mr. Zaleski of duties as attorney of record in this case.
Okay, thank you. Lo que estoy haciendo ahora, entonces estoy eximiendo eximiendo al abogado Zaleski de tener que cumplir con esta responsabilidad o de tener la responsabilidad como abogado en este caso.
You will be appointed as standby counsel.
Él será nombrado como o asignado como un abogado simplemente a un lado o a la espera.
Your case is set for trial during the trial period, which will begin on November the 2nd. Pre-trial will be on October the 20th.
Pre-trial will be October when, Your Honor?
20th.
20th, thank you. Su caso está programado para comenzar con el juicio, o podría comenzar el juicio a partir de las semanas programadas para juicio, que es del 2 de noviembre, pero la vista preparatoria está programada para el 20 de octubre.
You do qualify for court-appointed counsel, and if at any time during this process you decide you wish to be represented by counsel, you can let me know at the next court proceeding.
Y usted usted reúne los requisitos para que se le pueda nombrar a un abogado, que el juez le pueda nombrar a un abogado. Si usted en cualquier momento decide durante este proceso que desea ser representado por el abogado nombrado por el juez, simplemente me lo tiene que dejar saber en la próxima vista.
Thank you, sir. All right, thank you.
Gracias.
Your Honor, I do want to say that we have multiple media on discs that I don't know how he would receive those, but we have probably 10 CDs, which means we've gone through the videos that on it, but there's also other CDs of people who are testifying as far as witnesses.
Bueno, su señoría, nosotros tenemos múltiples discos, ¿verdad?, con contenido y no sabemos realmente cómo es que lo recibiría. Hay como 10. Nosotros los hemos visto o repasado los videos, pero hay otros CDs o discos que contienen personas que están testificando, posibles testigos.
Well, I don't know if you can receive the discs at the jail.
I don't know.
Check with the jail, see if they'll allow them to receive those. If not, we can readdress that. Okay. Ms. Pennell.
Judge, I have Gianni Pichardo. He's set for arraignment today, and he is in Orange County Jail.
Okay.
The court late last week appointed Mr. Tamarkin to represent him. I wasn't aware of that at the time Mr. Tamarkin was here.
Okay, he's gone.
I think we just need to reset arraignment because the defendant can be present either.
I was thinking he was,
Mr. Tamarkin is court appointed on 2 cases since it was a juvenile case. Mr. Selesky is on 1 case and just filed a notice, a motion for
okay. So in case 20 CF 2456, I'll grant the Regional Conflict Council's motion to withdraw and appoint Daniel Tamarkin to represent Mr. Pichardo. And I'll reset the cases for arraignment. On, well, he's not in our jail. I'll reset him for arraignment on October the 19th at 8:30. And I think Mr. Tamarkin may be waiving arraignment, but you can talk to him. All right, thank you.
Thank you, Judge.
All right, Danny Doty.
Your Honor, if I could ask, are we withdrawn with the exception of being standby attorney? Okay.
Doty, raise your right hand, please. You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
What is your name, sir?
Danny Neil Doty.
Mr. Doty, Mr. King has submitted a written plea form to the court in case 20 CF 73, which says you wish to resolve this case by entering pleas of no contest to aggravated assault with a deadly weapon as charged in count 1, petty theft as charged in count 2, and resisting merchandise recovery as charged in count 3. Is that what you want to do?
Yes, sir.
Count 1 is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Count 2 is a misdemeanor punishable by up to 60 days in the county jail, 6 months probation, and/or a fine of up to $500. And count 3 is a misdemeanor punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand?
Yes.
Very well. Mr. Doty, did you read and understand the written plea form?
Yes.
Do you have any questions about anything on the written plea form?
No.
Are you currently under the influence of medication, other drugs, or alcohol?
No, I'm not.
Are you thinking clearly at this time?
Yes, I am.
Did any person coerce or force you to enter this plea?
No.
Your recommendation I'm having a hard time making out. Mr. King, can you help me as to what the recommendation is?
Yes, Your Honor. It's an adjudication of guilt, credit time served, 10 months in the Osceola County Jail and court costs. On
Okay.
count 1, count 2, adjudication of guilt, 60 days, that's the maximum. Credit time served, and count 3, credit time served, 10 months, concurrent.
Okay, what's the time, sir?
He has 158 days.
All right, so Mr. Doty, if I accept your plea, the recommendation is you would be adjudicated guilty of all counts and essentially sentenced to 10 months in the county jail with credit for the 158 days that you've already served. There would be a fine, court costs, public defender lien, and application fee. Is that your understanding of the agreement?
Yes.
Are you satisfied with your lawyer?
Yes.
Do you believe it is in your best interest to enter this plea?
Yes.
Do you understand that if you are not a United States citizen, entering this plea will subject you to deportation?
Yes.
If you at any time are sentenced to state prison in Florida, and if you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete the prison sentence imposed by the court, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand? You have the right to have a jury trial. If you chose to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty at your trial unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. You would have the right to be represented throughout your trial by Mr. King. You would have the right to confront and cross-examine any witnesses who testified against you. You would have the right to present witnesses and evidence in your defense at trial. You're entitled to have the court order any witnesses you had to be present at the trial so you can present their testimony. You also have the right at trial to testify yourself, or you could choose not to testify. If you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand that you have those rights, sir?
Yes.
By entering a plea of no contest, you're giving up the rights we've talked about, excuse me, as well as the other rights that are written on the plea form, and there won't be a trial in your case. You also, by entering the plea, are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes.
All right, I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties that you're facing, and you understand the rights that you're giving up by entering the plea.
Yes.
I find that your decision to enter the plea has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've expressed satisfaction. I find that there's a factual basis upon which the plea can be accepted based on the arrest affidavit by Deputy Alessandri. I will accept the plea of no contest. Mr. King, do you agree the score sheet with 38.6 total sentence points?
Yes, Your Honor.
It appears that your client may be entitled to a PSI.
We waive PSI, Your Honor.
Okay. Anything further to be said before sentence is imposed?
No, Your Honor, nothing from the defense.
All right. All right, Mr. Doty, you'll be adjudged guilty of aggravated assault as charged in count 1. Petty theft as charged in count 2. and resisting merchandise recovery as charged in count 3. As to counts 1 and 3, you'll be sentenced to 10 months in the Osceola County Jail, credit for 158 days, time served. Excuse me, count 2 will be 60 days in the county jail with credit for 60 days, time served. Those sentences will run concurrent with each other. You are to pay a fine of $250, court costs of $415, a $100 cost of prosecution, $100 public defender lien, $50 public defender application fee. There is a required court cost of $201 pursuant to Florida Statute 938.08 and $151 pursuant to Florida Statute 938.085. Now, Mr. Doty, how do you generally support yourself, sir?
I get disability.
I'm going to order that you pay the money that's owed at the rate of no less than $40 every month. You'll have until February 1st of, I'll make it April 1st of 2021 to make your first payment. You have 30 days to appeal. The judgment and sentence was just entered. If you wish to appeal and cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days, you waive your right to appeal. Do you understand, sir?
Yes.
Thank you, sir. Good luck to you.
Thank you, Your Honor.
All right. Thomas Sanchez. State your name, sir.
Thomas Jonell Sanchez.
Sanchez, you're charged in case 20 CF 2375 with burglary of a structure in count 1, grand theft in count 2, and criminal mischief in count 3. Counts 1 and 2 are both third-degree felonies, which are punishable by up to 5 years state prison, 5 years probation, and/or fines up to $5,000. Count 3 is a misdemeanor punishable by up to 60 days in the county jail, 6 months probation, and/or a fine of up to $500. Do you understand what the charges are, sir? All right, we'll accept the plea of not guilty. Mr. Sanchez, your case is set for a jury trial during the trial period, which will begin on December 14th. Retrial is on December 2nd. Ms. Cronk will be in touch with you between now and then. All right, thank you. We have Robert Ortiz, that was scheduled as a competency hearing.
Yes, Your Honor.
And I do have,
Do you have the report?
no, I've got the order appointing Dr. Arias.
May I approach?
Yes.
I did email this to the state. I believe it's Mr. Hamilton's case.
All right, good morning, Mr. Ortiz. Please tell us your name.
Stephen Ortiz, Jr.
Okay, Mr. Mendoza, are you offering this report into evidence?
Yes, Your Honor.
Made any objection?
I thought Mr. Hamilton was online.
Mr. Hamilton, you're muted, I think.
Nothing to say, Your Honor.
All right, then a report from Dr. Alejandro Arias, which reflects the date of examination of August 31st of 2020 will be received. And evidence is Defense Exhibit 1 for the purpose of this hearing. All right, any additional evidence, testimony, or argument on the issue of competence, Mr. Mendoza?
No, sir.
State?
Nothing to say, Judge.
All right, very well. Mr. Ortiz, based on the report from Dr. Arias, I do find that you are presently competent to proceed in this case. So we need to set your case for trial docket.
Your Honor, may I make a recommendation?
Yes, sir.
Is your next video feed on the 29th? I know that's the first day of the trial docket.
Probably, yeah.
Because I believe that Mr. Hamilton and I are very close.
All right. I'm going to set the case for the November 2nd trial period, pretrial, October 21st, and we'll set it for status on September 29th and see if it's parties can reach a resolution.
Yes, sir.
All right,
Thank you. Thank you, Mr. Ortiz.
Okay, Mr. Keeley, if you'll come back up. All right. Morning again, Mr. Keeley. So it's all in one place on the record. If you'll please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? Excuse me, state your name, please. All right, Mr. Keeley, you are here at this time in two cases. In case 18 CF 2593, a plea form was submitted which indicates you wish to enter pleas of no contest to fraudulent use of personal identification information is charged in count 2. Fraudulent use of personal identification information is charged in count 3. Possession of an unauthorized driver's license is charged in count 4. Possession of an unauthorized driver's license is charged in count 5. And resisting an officer without violence is charged in count 6. Is that what you want to do, sir?
Yes, Your Honor.
All right, counts 2, 3, 4, and 5 are all third-degree felonies, each of which is punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Count 6 is a misdemeanor, which is punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. Do you understand, sir?
Yes, Your Honor.
All right. In case 18 CF 3439, the plea form submitted by Mr. Zaleski indicates you wish to enter pleas of no contest to fraudulent use of personal identification information is charged in count 1, and unlawful possession of a stolen credit or debit card is charged in count 2. Is that what you wish to do?
Yes, Your Honor.
All right. And again, each of those charges is felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Do you understand?
Yes.
All right, sir. Did you read and understand the written plea forms?
Yes.
Do you have any questions about anything on the written plea forms?
No.
Are you currently under the influence of medication, other drugs, or alcohol?
No.
Are you thinking clearly at this time?
Yes.
Has any person coerced, pressured, or forced you in any way to enter these pleas?
No.
The recommendation is that you would be adjudicated guilty of all counts to which you are pleading. You'd be sentenced as to all felony counts to 2 years in the Florida Department of Corrections with credit for the time you've served, which would be
In case 18 CF 3439, 726 days. 18 CF 2593, 795.
okay, so it'd be sentenced to 2 years DOC with credit for 726 days and 795 days respectively. There'd be restitution ordered in case 18 CF 2593 of $477, cost of investigation in that case of $304. There'd be a conflict counseling and public defender application fee. Is that your understanding, sir?
Yes, Your Honor.
All right, are you satisfied with your lawyer in these cases?
Yes, Your Honor.
You believe it's in your best interest to enter these pleas?
Yes.
You understand that if you're not a United States citizen, entering these pleas will subject you to deportation.
Yes.
If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence imposed by the court, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand? You have the right in each of these two cases to have a jury trial to determine whether the state can prove that you committed these crimes. If you chose to go to trial at each one of your trials, you are entitled to a separate trial in each case. At each one of your trials, you would be presumed to be innocent. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond and to the exclusion of every reasonable doubt. You have the right at your trials to be represented by Mr. Zaleski. You'd have the right to confront and cross-examine witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You're entitled to use of the court's subpoena power to require any witnesses you have to be present at your trials. You also have the right at each trial to testify yourself, or you can choose not to testify. If you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand that you have those rights?
Yes.
All right, by entering pleas of no contest, you're giving up the rights we've talked about, as well as the other rights that are written on the plea form. And there will not be a trial in either case. You're also giving up your right to appeal any matters relating to these cases, other than the jurisdiction of this court to hear your cases and the legality of the sentences imposed. Do you understand?
Yes.
All right. All right, I find that you are alert and intelligent, that you understand the nature of the charges against you, the penalties you're facing, the rights you're giving up by entering the pleas, and I find that your decision to enter the pleas has been freely and voluntarily made, and you've had the advice of competent counsel with whom you've expressed satisfaction. Based on the arrest affidavit in case 18 CF 2593, as well as the affidavit for arrest warrant in case 18 CF 3439, I do find in these cases there's a factual basis upon which your pleas can be accepted. I'll accept the pleas of no contest. Mr. Zaleski, any objection to score sheet with 46.2 total sentence points?
No, Your Honor.
Or anything further to be said before sentence is imposed?
No, Your Honor.
All right, in case 18 CF 2593, you'll be adjudged guilty of fraudulent use of personal identification information as charged in count 2. Fraudulent use of personal identification information is charged in count 3. Possession of unauthorized driver's license is charged in count 4. Possession of unauthorized driver's license is charged in count 5. And resisting an officer without violence is charged in count 6. As to counts 2, 3, 4, and 5, you'll be sentenced to 795 days in the Department of Corrections, I guess, with credit for 795 days that you've served. That's actually a little more than the 2 years.
Yes.
And you'll be ordered to pay court costs of $415, a $100 cost of prosecution, a fine of $500, restitution of $477 to Lillian Castro Garcia, cost of investigation of $304 to the Osceola County Sheriff's Office. There'll be a $100 regional conflict counsel lien, a $50 public defender application fee. The money that is owed is ordered to be paid at the rate of no less than $50 every month. You'll have until April 1st of 2021 to make your first payment. Payments need to be made to the clerk on the second floor of this building. In case 18 CF 3439, you'll be adjudged guilty of fraudulent use of personal identification information as charged in count 1, and fraudulent use of a unlawful possession of a stolen debit or credit card as charged in count 2. And state there are a couple of days difference, but I'm inclined to just do it. The 726 days. Okay. So as to each count, you'll be sentenced to 726 days incarceration with credit for 726 days time served. Incarceration. However you want to put it. It could have to be DOC, I guess, but. Okay. All right. With credit for 726 days time served, you're ordered to pay court costs of $415, $100 cost of prosecution, a fine of $500, $100 public defender lien, $50 public defender application fee, all of which is ordered to be paid at the rate of no less than $50 every month, consecutive to the payments ordered in case 18 CF 2593. Is there anything further with respect to these two cases?
No, Your Honor.
Oh, I'm sorry, I did not, the misdemeanor will be 365 days in the county jail, credit for 365 days time served. That's count 6 in case 18 CF 2593, and Ms. Merced, you'll be non-prosecuting count 1?
Yes, Your Honor, State with no cross count 1 and 18 2593.
Okay. So that leaves us with the other case.
Yes, Your Honor, Ms. Smith Hammerhoff emailed me to advise that she is in the waiting room.
She's not there. Neither is Mr. Tamarkin. Mr. Keeley, you also have your motions that you filed in case 15 CF 495, in which you are representing yourself. You have standby counsel, who is Mr. Tamarkin, and that's a statewide prosecutor case. It was set for 10 o'clock. Mr. Tamarkin was here earlier, as you may have seen. Ms. Hammeroff from the Office of Statewide Prosecution apparently was on the
I just sent her an email.
line. Well, I may just reset these. When's our next jail feed? Tomorrow after 2 o'clock? Mr. Keeley, I know you're getting out on these cases today, so we need to get moving on your other case and particularly address the motion to dismiss as well as your motion for bond reduction.
Your Honor, I have a question.
Yes, sir.
If the state is not ready today, is the court gonna continue the case, or will my case be dismissed?
I'm gonna recall it tomorrow at 2 o'clock.
And if they're not ready then, will my case be dismissed?
I'm sorry?
And if the state isn't ready then, what happens after that?
I'm sorry, I'm having a hard time.
Because the state didn't show up today, right?
Well, they showed up, and I don't know where they are.
She emailed me back, she says she's definitely in a waiting room, she's gonna exit and try again, she's not sure why it's not coming
Oh, I know
up. She
why.
also has a witness that's there, Bradley Lewis.
Okay, I know why it's not working, because Ms. Keene made it 2 separate invitations. So let me pull that one up. One was at 8:30, one was at 10 o'clock. So we'll have 2 separate sessions of teams going.
She said she's in as RF and not RE.
All right, I've got her. And Mr. Markin's there as well. Okay, good morning.
Good morning.
Good morning, Judge.
Good morning. I'm sorry, Ms. Keene set up 2 separate teams meetings this morning, and I was looking for you on our 8:30 meeting, and this was separately set at 10 o'clock. So Mr. Akile is present. He resolved his other 2 cases, and we're here right now in case 15 CF 495. Let's start with the motion to dismiss. Are you ready to argue that, Mr. Akile?
Yes, sir.
Okay, you may proceed.
The state filed in 2015. The case occurred in 2012, and I was arrested in 2018. More than 5 years has passed since that time of arrest. I've been in Florida the entire time and been available the entire time. I've been staying at the same address. I received government assistance. I've gotten a new ID. I've updated my address with Bank of America, and I've been available ever since then. The state just ended up arresting me in Kissimmee in 2018, so I haven't left Florida the entire time.
All right, Ms. Amroff? I'm sorry, you're muted.
If I could ask the defendant what that address was that he was residing at.
3202 McEwen Lane, Orlando, Florida 32812.
I'm sorry, I missed the number and the street name.
3202 McEwen Lane?
Yes, sir.
Your Honor, I do have my witness, Bradley Lewis, on the line. If I could call him as a witness.
All right, Mr. Lewis, if you'll raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, you may proceed.
Thank you, Judge. Good morning. Could you please state your first and last name for the record and spell both of those?
It's Bradley Lewis, Bradley, last name of Lewis, Lewis.
And what do you do for a living?
Special agent with the Florida Department of Law Enforcement. I'm attached to the FBI Safe Streets Task Force.
And how long have you been working with the Florida Department of Law Enforcement?
Approximately 15 years now. 14 years, 15 years.
So taking you back to late 2012, early 2013, you were still with FDLE, correct?
Correct.
And did you come to investigate a multi-defendant, multi-circuit case involving a Ridge Achilles?
Your Honor, I cannot hear the state.
I'm sorry, excuse me. Yes, sir?
I can't hear the state at all.
Okay, Ms. Amroff, I'm going to ask you to try to speak up if you would.
Oh, sure. Could you tell the court a little bit about that case?
It was a multi-jurisdictional investigation. We had received reports from various agencies regarding some commercial burglaries that were happening primarily to stores that sold electronics, i.e. cell phones, things like that. So they called in and requested assistance based on the fact that there were multiple jurisdictions, and most agencies only have one jurisdictional scope in the state.
And how many defendants were involved in this investigation?
I believe approximately 7. I'd have to go back and check. It has been a while.
And once it was decided that this case was ready for filing, were warrants issued for all of the defendants or all the suspects?
That is correct.
And how many were initially arrested on those warrants?
I would have to review my records, but I think initially we picked up 4 or 5 on the same day, and then a couple were in the wind, and we got most of them, with the exception of Mr. Achilles, very shortly after the warrants were entered. But I'd have to clarify that by looking exactly on the dates and things.
No problem. For the ones who were immediately arrested, how were you able to locate them?
Generally, as a rule of thumb, we rely on our analyst a great deal. We'll request information about current information, either through driver's license databases and other databases that hold that information.
And did you employ those same techniques that you used to locate the other suspects as you did for Mr. Achilles?
I did.
And now let's get into the specifics regarding your attempts to locate Mr. Achilles. Do you know when his warrant was issued?
I would have to check real quick, and I can, if it's okay with the court, I can just click on, since modern technology allows us to do that now, since I'm not in the courtroom right now. I will tell you in a second.
May I have permission to do so, Your Honor?
He may.
Okay. Okay, according to my report on February 9th, 2015, myself and the statewide prosecutor went to Osceola County, and I think both appeared before you, Your Honor.
And that's the record the state has as well. So what did you do once Mr. Achilles' warrant was issued?
We attempted to locate him. There was the primary thing was Rose Lane, was his last known. According to his co-defendants, that's where he was staying at. That's where they went after several of the burglaries. So we went and basically attempted to find, and the addresses that we knew where he was staying at or had reasonable belief where he was staying at, we went and did a real comprehensive search with several parties, several different teams.
And were you successful in locating Mr. Achille at that point?
We were not.
Did you turn in February? Did you turn to any other agencies to help you locate him?
In February, I don't believe we did. I believe it was, I'd have to review my records, but I believe it was all pretty much FDLE agents from the Orlando regional area. Were doing the search at that point, but I'm not sure. We could have, I mean, it involved so many different agencies at the time. I may have requested assistance from Orange County because they were involved, OPD because they were involved. So it could have been multiple agencies, but I'd have to review the record to find out specifically.
Do you typically work with the felony apprehension unit at the Orange County Sheriff's Office?
Yes. Yeah. From time to time when it's needed, we will.
Okay. And do you know if they assisted you in this case?
They did.
Now, I'm going to take you now to October of 2015. Who, if anybody, did you ask for help at that point?
In October of 2015, and I'm reviewing my notes, if that's okay with you, Your Honor.
That's fine.
October of 2015.
October 9th, of 2015, did you request additional analytical assistance?
Yes, it does look like I request analytical assistance regarding the whereabouts of Mr. Achilles and Mr. Rodriguez.
And did you receive anything new to your knowledge at that point?
I don't believe we did. I think we do a log. When we do things, we'll generally just keep a handwritten log or an entered in the system, but I don't believe we found anything that was new that was a different direction to look at.
And what about moving 2 months later to December of 2015? Did you again request analytical assistance for help with his whereabouts?
That is correct.
Jumping now to about 7 months later, July of 2016. At that point, had you located Mr. Achille yet?
We had not. I believe we found Mr. Rodriguez by that point, but we're not able to find Mr. Achilles at that point.
Then in July of 2016, did you implore the services of a Susie Murphy to request information?
Yes, ma'am, we did.
And who is Miss Murphy?
Ms. Murphy is one of our intelligent analysts. So she did a query of the databases, known databases, to find if there were any new information.
Now, the defendant, prior to you starting your testimony, the defendant testified that he had been living at 3202 McEwen Lane in Orlando. In August of 2016, did you in fact look for him at that location?
Yes, we did, 3202. Myself and I think it was 2 road patrol guys from Orange County that work in that area. I requested their assistance, and we made contact at that time, I think, with his stepfather, with Mr. Achilles' stepfather.
And when you spoke to the stepfather, did he say that Mr. Achille was still living there?
He said he was not living there.
And where did he tell you that Mr. Achille was living?
So he was living with his brother at that point, and I think it was Billy, if I'm not mistaken.
And at that point, learning from the stepfather that Mr. Achille was living with his brother, what actions did you and FDLE take at that point?
I contacted one of my coworkers who was assigned to one of the violent crime squads, and he basically, we linked in with the felony squad from Orange County, and they set up on Billy's house to try to get surveillance and try to see if we could get any sightings of Mr. Achilles.
And did you have any success at that location?
They did not.
And just for the record, that would have been January 23rd of 2017. Is that correct?
Correct. Yes, because that was when we also went out to there were a couple new addresses that had been produced, I believe, back in that time frame regarding Mr. Achilles' mom, and it moved. out to certain addresses in Lake County, and I went out there and searched a couple houses or made contact with some people at different residents in Lake County, because that's where the mom's address had moved to.
And did you have any success with finding Mr. Achille at those addresses?
We did.
Did you again try to request analytical assistance on January 24th of 2017?
I did.
And do you know a Detective Cartagena from
Yes.
Orange County? Did you speak with him on February 2nd, 2017?
I did.
And what was that in regards to?
That was there again, trying to get an update, seeing if they've had any success with the surveillance at Ridge's Brothers residence where Mr. Achilles was allegedly staying.
And and how long did the surveillance last at the 3202 McEwen Lane residence?
I did not get specifics on how long they stayed out there and how many times they went out there. I believe, if memory serves me correctly, they said we've been out there a number of different times. We've seen the brother. I think they said they saw the brother's wife or girlfriend. They had sightings of people coming and going into residence, but no sightings of Mr. Achilles himself.
And moving now to March 29th of 2017, at that point, did you start working with analyst Karen Weir for assistance?
That is correct.
And who is Karen Weir?
Karen Weir is another analyst for FDLE.
Let's see. Jumping forward to June of 2017, did you then speak with Ms. Weir?
I did.
And at that point, had she been able to get any new information for you in those, 3 or 4 months regarding Mr. Achilles' whereabouts?
She did not. Best I recall, I don't think there was anything that, I think she confirmed that the warrant was still active because we have someone's name flagged in NCIC, FCIC. So if anybody gets run by law enforcement, we should get instant notification 24 hours a day. So I had her check to make sure that his warrant was still active. Have you found any new addresses? Just basically do another database query. And she said she found nothing that was indicative of him, of current whereabouts.
Okay. And jumping forward to January of 2018, what, if anything, did you do at that point?
Again, I think I requested another update regarding the whereabouts of Mr. Achilles.
And was there anything that was successful or new in locating him?
Again, nothing was identified via my analyst or one of the analysts.
Moving then to April of 2018, did you then contact an Andrea Lubrano?
Yes, I did.
And who is Ms. Lubrano?
Ms. Lubrano is also one of FDLE analysts.
And was she able to provide any new information?
She was not.
Moving then to June 20th of 2018, did you then start talking to the U.S. Marshal's office or Marshal Service?
Correct, I did.
And did you speak to a Brian Guilford there?
I did.
And at that point, were you able to, why did you reach out to TFA Guilford?
Well, based upon the fact that we have not had any success in finding Mr. Achilles, we reached out to Task Force Agent Guilford and asked him if he could go on off and run his databases, if they had time to set up on some of the locations, because I don't know specifically what databases they have access to in comparison to our FDLE analyst. So I wanted to just try to discover bases and have another database check and or have them set up if they found something, just to in general to obtain their assistance.
And was in fact that about a month after that, Mr. Achille was apprehended based on some new allegations in Kissimmee.
That is, as I understand it, yes.
And before he was apprehended in July, was TFA Guilford able to provide any assistance?
They did not.
That is all my questions, Your Honor.
All right. Mr. Achille, do you have any questions for Agent Brett?
Yes.
May proceed.
You said that the co-defendants gave you the address to 8525 Rose Grove Road, right?
Sorry, say again?
You said you obtained the address from my co-defendants of 8525 Rose Grove Road because they said that that's where they go to after the alleged crimes occur, and that's where they believe I stayed at, correct?
They had mentioned that was one of the places you were staying at your mother's house, correct?
So that address wasn't obtained through a database, was it? It was obtained through my co-defendants, correct?
No, I believe it was also confirmed through your mother's driver's license address, but I'd have to confirm my notes.
So you're not 100% sure on that, are you?
Not 100% sure. What, can you rephrase the question?
That did you obtain the address from my co-defendants or through a database?
I believe both.
Are you 100% sure?
I am fairly certain, but I wouldn't say 100%. I'd have to go back and check my records, but I'm fairly certain that was an address your mom had on her address, as well as that was across the street from where a lot of the items that were stolen during these burglaries were found. And your co-defendant said at times you would go back to your house or would leave your house prior to the burglaries.
But you did say that you got an address from my co-defendants earlier, did you not?
Objection relevance and asked and answered.
No, it's, you did ask that, and he's already answered it. He got that, at least from one source from your co-defendants.
And all the statements that you made from everybody else, those are third-party statements that you've obtained information from them, correct? Because they're not present right now, so you're answering for them, correct?
I'm testifying to what they told me.
So I can't cross-examine those people, so you're just speaking for them from what you've heard.
I am testifying to the fact that I heard it from your co-defendants, and I obtained it from a database called David, driver's license database from the state of Florida.
Okay, what, did you use any, did you check with the banks?
I don't, like I say, I don't know specifically what my analyst checked.
Did you check for food stamps?
I did not check for food stamps. Again, I'd have to refer to what my analyst checked.
What did you use in order to find out addresses or anything that you said you obtained? What did you use as a database?
Objection asked and answered.
Overruled.
What I personally utilized was testimony from your co-defendants, as well as the access to the driver's license database. As far as what my analyst, I don't want to speculate on what databases they utilize, because I don't have knowledge pertaining to that.
So you know with the statute of limitations, diligent search, you have to use obvious sources of information. So what obvious sources of information did you use other than that?
You're asking me the same question again. I'm missing. I'm trying to hear.
So you did not use obvious sources of information, correct?
Obvious to who? I'm not sure I'm following.
That calls for a legal conclusion, so if you want to ask him something specific, you may do so, Mr. Keeley.
So from your understanding, you only searched one address, correct?
No, there were multiple addresses that were checked.
No, I'm saying from the information you said earlier, you said the only thing you personally have checked was the 8525 Rose Grove Road.
No, I don't believe that's the case. You asked me what checks were done, where did I get my information from? And I said from the Driver's License Bureau, or through our analyst, or through your co-defendants.
So you don't know what sources of information the analyst used?
That is correct.
So the addresses could have been obtained from anywhere?
Could have been obtained from any lawful venue as far as databases that they use. I don't want to speculate. I don't have any idea if I don't want to speculate on what those databases are.
So do you know why they weren't able to find Mr. Achille?
Can you repeat the question?
Do you know why they weren't able to find Mr. Achille?
I can only speculate to that. I mean, my understanding is when Mr. Achilles was arrested, he had a false ID on him, a phony driver's license, so it could have been that he was using phony, false or fraudulent identification. Could be he was, as I think we were referred to, couch sleeping. Could have had people covering for him. It could be a number of reasons why he was not found. I can't speculate on that because I wasn't with him.
So you're here just to testify what you've heard from other people, correct?
No, sir, I'm here to testify on the efforts that we put forth to find Mr. Achilles, which was documented in our logs and or reports.
But you're not the one who went after to go to apprehend Mr. Achilles, is that correct?
No, that is not correct.
You asked for assistance to apprehend Mr. Achilles, but you're not the one who went to the house, are you?
Yes, I was.
So you spoke with Mona and my stepfather?
Can you say again? I'm having a difficult time hearing you.
Did you personally speak to my mother and stepfather?
I was at the residence, yes.
And he told you I did not live there?
He told me that, told myself and the deputy that I was out there with, that he said that you had moved, you were staying with your brother Billy, I believe. It was with your brother. I don't recall if it was Billy, but I believe it was Billy.
So, again, you're speaking for a third party because my parents aren't here to testify that they told you this, correct?
As far as I know, they're not here.
So everybody else that you said that gave you this information, none of them are here but you, correct?
I'm sorry, repeat. Can you please repeat?
Everybody that you're giving testimony for, they're not here for me to cross-examine them. So you're just giving out information that you've heard.
I think that's been asked and answered. Let's move on, Mr. Akili.
Well, Your Honor, in the statute of limitations, it says obvious sources of information has to be obtained through the database. They either have to check with...
Well, you're getting into argument now, Mr. Akili, and you'll have the opportunity to make argument. But right now, if you have any questions for Agent Lewis, you can ask him. You've already asked him about what he received firsthand and what he may have received secondhand. So if you have other questions, you certainly may ask.
What other addresses other than 8525 and 32 McEwen Lane have you checked?
Like I mentioned, we were out in Umatilla. I believe it was Umatilla, Lake County. There were a couple addresses we checked out there that showed up, I think, that were linked to your mother, I believe.
Not to me, correct?
Answered yes.
All right, I have no further questions for him.
All right, thank you. Ms. Hamaroff, any further questions?
No, Your Honor.
All right, thank you, Agent Lewis. Any additional evidence or testimony from the state?
Just argument, Your Honor.
Any evidence or testimony from the defense?
Yes, Your Honor. The entire time I was residing...
Well, again, we'll get to argument, but did you have evidence or testimony? Are you wanting?
No, Your Honor.
Okay. I mean, if you want to testify yourself beyond what you have earlier, you may do that as well.
Yeah, the entire time I was staying at 3202 McEwen Lane. I did not leave from that residence. I had food stamps. I've updated my address. I've even received furniture at that address. My family is not here to testify, or anybody else to testify, that they've said these things to the officer. The entire time I was there, I was even arrested in Kissimmee during this time frame. So there's not one time that I've moved any other location. All my addresses, if they would have done a background check, they would have seen that was my address. If they wanted to obtain they were just lacking. They wanted to obtain any kind, my phone number was with food stamp. I had a Bank of America account for about 15 years. The entire time I've been in one place. If they wanted to just look up my phone number, they would have been able to call me or find out where I was at during that time. I was unaware during that whole time I had a warrant for this RICO Act. They even came and spoke to me before about this crime, and they left it alone. For 2 years, they just waited to charge me. They came to actually talk to me and asked me if I had any involvement with this crime. And they knew where I was the entire time, but they never issued a warrant during that time. I told them I had no involvement with this, and I did know certain people that were involved with the crime. But my involvement, I did not have any kind of involvement. they waited the entire time where they knew where I was at. They waited and no arrest was made. And then I moved to 3202 McEwen Lane during that time, and I've never moved from there. So I don't know if they just didn't see me at that time, but I did not move from there. And some of the allegations this man has made, I should have the right to cross-examine these testimonies to these people that he said this. And none of them are in the courtroom, so I don't understand how you could even make those statements for a third party.
All right. Ms. Hamroff?
Yes, Your Honor. First of all, of course, in a motion to dismiss hearsay, evidence is permissible as long as it's not the sole basis. It is perfectly reasonable for FDLE to utilize their analysts, which is what Agent Lewis did in this case. He utilized not only the analysts that he had at FDLE, but also asked other agencies around Central Florida to help him out, since they had not at that point been successful in locating Mr. Achille. I walked Mr. Lewis through all of the efforts that he and FDLE took to locate Mr. Achille, and it was every few weeks at least. I believe the biggest time gap was about 6 months, and there still was no new intel as to where he might be. Law enforcement both checked the address that Mr. Achille says he was at on that Rose Lane address, and they also set up, multiple days of surveillance at that McEwen address, which he testified that he was living at the whole time. Law enforcement says that no, they saw people, constantly going in and out of the house, never Mr. Achille, and his own family members advised law enforcement, which Mr. Lewis was there for, that Mr. Achille, in fact, did not live there and was living with the brother. They tried that address as well to no avail. Law enforcement did do due diligence in this case. It was just that those new offenses that were committed in Kissimmee that the defendant was apprehended. Going to 775.15, the prosecution commenced if the information is filed, if the defendant has not been arrested, provided the capias is executed without unreasonable delay. The delay in this case, Your Honor, was not unreasonable. Agents tried numerous types of efforts and avenues to locate Mr. Achille. And I also looked at statute 812.035 sub 10, which talks about the statute of limitations not running during any time when the defendant is either absent from the state, which the state will admit we don't have any evidence of that, but also is without a reasonably ascertainable address or place of abode or work. Again, law enforcement tried every address they could possibly find for him to no avail. In that case, the statute of limitations should be extended for no more than 1 year. In that case, that would make the statute of limitations 6 years. And the Sheffer versus Judges of the 15th Circuit case, which is 614 Southern 2nd 632, out of the 4th DCA, states as long as one predicate in a RICO is within the statute of limitations, the entire RICO is considered timely filed. Your Honor, therefore, under 775.15, the state would argue that the state did plenty of due diligence in order to find Mr. Achille, and if for some reason the court does not find that the state did so, even under 812.035 sub 10, the state would argue that we would at least get that 1 extra year on the statute of limitations for him not having a reasonably ascertainable address. So for both of those reasons, the state is asking the court to find or to deny the motion to dismiss.
All right. Mr. Keeley, anything further?
Yes, Your Honor. The statute of limitation on the RICO is 4 years. The thing she's talking about, the place of abode, if they would have done a simple background check on me, like the dude said earlier, he does not know what methods they used in order to find any data on you. And in State versus Mack, it suggests obvious sources of information the state must have checked, including telephone book, the city directory, driver's license records, vehicle license records, property tax records, voters registration records, the probation office, local utility companies, law enforcement agencies, the state attorney's office, school, armed forces, and prison system. If they would have checked any of those, then they would have been able to find me. And those were reasonable places of note. Just because they did an investigation, did not see me, and the officer was not able to provide that any kind of information on what kind of data they've used. They must show that they've used obvious sources of information. And during that time, I was there the whole time. He did not show surveillance. He was speaking for third-party people, and he did not offer any information on what kind of data they used in order to find me. And those things must be checked. And the state is not offering any kind of information to object that I've had a bank account, food stamps, or any other information. They don't have any kind of information to object those facts. She's just going around the board stating other types of facts. She's not objecting what I'm saying. I've had a bank account, I've had food stamps, I even had a new ID that they issued with the state of Florida. I have not been hiding or anything like that. The entire time I was at one address. She's not disregarding those facts. She's just going around other facts. She does not have any kind of information. I've submitted this, so she was able to read this paperwork. I submitted this like 6 months ago about this information. I just did an amended motion on the 31st. So she had time to read this. She could have got any kind of information to object the information that's on this motion, but she's not. She's going around it. But I've had obvious places that they could have searched for. And the dude earlier, he couldn't state what obvious information or what obvious data they've used. He was just stating that he went to this house. And 1 or 2 searches to a house is not a diligent search. It's not. So I don't understand how she's saying they did a diligent search, or I didn't have a reasonable place to stay at. And statute of limitation on that, on the RICOs, is only 4 years. So from 2012 plus 4 years is 2016. So anything they did after 2016 doesn't even matter, because the statute of limitation, it already passed. So I don't know what she's talking about, a reasonable place of a dough, and she's not even using case laws referring to what she's talking about.
All right, thank you. All right, I'm going to reserve ruling on the motion. I'll allow each side until this Friday at 5 o'clock to submit any additional case law or written argument you wish to make. Send a copy to the other side, and I'll rule
I have one
expeditiously.
comment, Your Honor.
Yes, sir.
And my motion to dismiss isn't just on statutes of limitation. It's on the grounds of the constitutional speedy trial. It's just that we were just talking about the statute of limitation, but my Sixth Amendment rights was violated. So I ended up putting that in the motion. I don't know if anybody read the motion, but.
I did. I understand your argument, and if you have any additional cases with respect to constitutional speedy trial, you can include that in what you submit to the court.
Yeah, and the state did not bring my parents to testify the facts. Every fact that the state has.
Right, I understand. Your argument is that it was all hearsay and second and third hand.
Yes, all of it was hearsay, because I have the right to cross-examination.
All right. Fair enough. Thank you.
Your Honor, I will have a hand copy mailed to the Orange County Jail, as well as I'll email a copy to Mr. Tamarkin.
Send it to the Osceola County Jail, if you would.
Or, I'm sorry, Osceola County.
All right. Thank you.
Sorry. Thank you.
Thank you. All right.
Good day.
Thank you. Thank you, folks. That's, okay, let's get back. We have Mr. Robert Ortiz. We addressed, we have Mr. White. We have Keone White.
Morning, Your Honor. Jose Lopez from Mr. White.
All right, Mr. White, raise your right hand. You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your name, sir.
Keon White.
All right, Mr. White had entered a plea back on March 10th of 2020 to kidnapping as count 1, aggravated assault is charged in count 2, aggravated assault is count 3. and aggravated assault as to count 4. Court ordered a PSI, which I have received. Mr. Lopez, have you had a chance to review the PSI?
Oh, yes, Your Honor.
I'm sorry?
Yes, I have, Your Honor.
Okay. And State, do we have a score sheet?
I do, Your Honor. I provided this score sheet to Mr. Lopez a few weeks ago. I will point out for the court that it is slightly different than the score sheet that was provided at Mr. White's plea date. However, the difference in the total sentence points is actually, it avers in Mr. White's favor at 170.0 total points, whereas at the score sheet at his sentencing date, it was 170.2 total sentence points. The difference is J&Ss that I received from the state of Pennsylvania.
Okay.
Right. If I may brief. Oh, no, that's fine. No, I saw it already.
All right, is there any objection to the score sheet with 170.0 total sentence points?
No, Your Honor, but I'd like to address the court before we commence.
Yes, sir.
Your Honor, Mr. White was actually, he was arrested in Polk County. There was a transport order that was issued previously, and they hadn't transported him over, so we ended up having to reset the sentence until today.
Right.
Unfortunately, I believe they transferred him over late Thursday. I was notified on Friday. I wasn't able to coordinate his witnesses for the sentencing because.
Are you asking to reset the sentencing?
Yes, Your Honor, because they're all out of state. They all live in Pennsylvania.
That's fine.
Judge, may I be heard on that issue?
You may.
This was reset from a point in the summer for Mr. White to get his witnesses down here. We've had this date of September 21st today for almost a month now. I believe the last date we were supposed to sentence him was August 31st.
I'm going to give him an additional time over objection. But it won't be reset again from that.
And I understand that, Your Honor, it was just that situation. It has been reset, and the state's correct. It has been reset. There was a couple of issues between.
Okay. Well,
I think the only thing I would ask, Your Honor, is if the court minutes would reflect that he remain in the county jail. That way, they don't get send them back to Polk.
has he got open case in Polk?
Yes, he does, Your Honor.
He has, I think, 2 open cases in Polk. He has 2 open cases here in addition to this one.
All right. We'll set the case for sentencing on October 5th at 8:30. And hopefully I won't be setting in custody and out of custody things on that same day, which screws everyone up. It's caused people to wait a long time this morning. But in any event, we'll set it for October 5th at 8:30. Thank you.
Thank you, Your Honor.
All right. So I think that's all the folks we have in this group.
I believe Mr. DeSales was in the back, Judge.
Mr. Who?
DeSales. It looks like they brought some new people in there and in the back.
Who do you see?
DeSales.
Okay. And what's happening in Mr. DeSales' case?
Judge, I had asked Ms. King, this is the case that was gonna be, supposed to be, at some point, gonna be a bench trial, but, we were working on,
Yeah.
right. So he hasn't had a court date for a while, so essentially I asked Ms. King to give it a court date, and she said, how about we status it so that Judge, so you can give us a court date.
Well, it was set for another retrial at one time, I guess.
And I believe Mr. Sorry, you threw me off when you looked at me. I believe Mr. Moffitt indicated it still would. We still do anticipate it being a bench trial.
Okay.
Ms. Adams, I guess, and I don't know if some of these things have been worked out. Originally, when we were gonna do it, Mr. DeSales was okay with being at the jail if he couldn't be transported.
Is this
but-
NGI?
Yes, Judge.
Resolution, okay.
But there were some issues with her, I guess, her witnesses are trying to figure out the logistics of it, and she hadn't figured that out prior to her leaving, so.
Okay, well, if you guys are agreeing to that resolution, you really don't need any witnesses. You can submit documentary evidence if there's no objection from the other side, so it can move pretty quickly that way. But so how much time do you, what? What?
We have the jail fee on the 6th.
Okay. The 6th
On the 6th, we switched to it.
of October, you're talking about? Okay. We can do it October 6th if you want.
Defense and I will have to coordinate exactly, so that way we're
Okay.
for sure what objections or what stipulations we can make, and
Okay.
we'll have good ideas to how long the bench trial will actually take. I would like enough time just in case I need to send any subpoenas out for any witnesses. even if
Right.
they're here in the
I'll set it for October 6th at this time.
Is that a morning or afternoon, Judge?
That'd be in the morning.
Okay. I had that was afternoon.
And again, a non-jury trial, if this is a stipulated agreement, it should take no more than 5 or 10 minutes, actually. But, if things develop otherwise, that's fine. Just let me know. We can reset it. We will need a signed waiver of jury trial from Mr. DeSalles if he's requesting a non-jury trial, though.
I'm sorry, a sign.
Need a written waiver of jury trial by Mr. DeSalles.
Okay. Did that have to be notarized or just signed?
Just signed.
Okay.
I'll go over it with him.
All right. I will work on that.
So we set for October 6th, yes.
I'm going to reset and Mr. White for the 6th as well, since we won't have the freedom today.
Yes. Okay. Thank you, Mr. DeSalles. Your attorney will be in touch with you. Thank you.
Have a good day.
You too. So who else do we have at the jail there?
I'm not sure who the other person is in the back.
We could have the other gentleman brought up. I don't know who that is.
Yes, sir, we have, Brittany, Hudson, and Sarah Mickelson. There's 3 left.
Okay, we can do, let's go ahead and do Mr. Hudson. This is a motion compel.
Your Honor, Richard Mendoza covering for Ms. Brown.
Yes, sir.
We'll be withdrawing the motion to compel.
Okay.
Discovery was received on Friday afternoon.
Okay, good morning, Mr. Hudson. State your name, please.
Kenneth Hudson.
Mr. Hudson, your lawyer set your case for hearing on a motion to compel this morning. Mr. Mendoza, who's your lawyer's partner, has indicated that she has received the appropriate discovery, so the motion to compel is withdrawn. So your case will just remain set for the 29th for trial at this time, all right? Thank you.
Thank you, Judge.
So,
I also have Mr. Bittner's case. I believe we're just going to leave that set for next Tuesday.
okay,
Richard Mendoza on behalf of Mr. Bittner. That's correct, Your Honor.
okay, thank you. So, he rattled off, I thought like 3 names. Was Bittner one of them? At the end of the jail?
It was,
Yes.
I think it was one of the names I mentioned.
There he is, Your Honor.
Okay. All right, Mr. Bittner, good morning. State your name.
Brendan Bittner.
Ms. Bittner, your attorney has indicated that the case will just remain set for next week.
Yes, Your Honor, the 29th, I believe.
So you're set for the 29th. We'll see you on the 29th, sir. Thank you.
Okay, did you know I'll be able to speak to you, Mr. Mendoza?
Yes, very soon.
All right, thank you.
Thank you. All right, good morning. What is your name?
Sarah Michelson.
Who?
What? Okay.
Want me to repeat it?
No, I've got you. Okay. Just a different stack of files. All right, if you'll raise your right hand and be sworn, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
State your name again, please.
Sarah Michelson,
And Ms. Michelson, what is your date of birth?
5/17/74.
All right. Ms. Michelson, you've been taken into custody here on a warrant out of the state of Wisconsin. The warrant is for failure to appear on charges of burglary of a building or dwelling and theft of movable property, more than 10,000, less than 100,000, and 2 counts of bail jumping. You do have the right to contest your extradition back to Wisconsin, or you can waive that right and agree to be voluntarily returned to that state. If you decide to contest extradition, I will schedule a hearing in 30 days to allow the authorities in Wisconsin time to obtain a requisition warrant from the governor of Wisconsin, which if it is entered, would be transferred to sent to the state of Florida to the governor here. Governor here would review it, and if he finds everything's in order, he would enter what we call a rendition warrant directing your return to Wisconsin. That 30-day period can be extended up to an additional 60 days for a total of up to 90 days to allow the authorities to obtain those warrants. We would then have a hearing to determine, first of all, whether they've obtained the warrants, and secondly, whether you're the person named in the warrants. We cannot address your guilt or innocence of the underlying charges, but just whether or not they've issued the proper warrants, whether you're the person named in those warrants. Do you understand all that?
Yes, so I can choose if I want to.
I'm sorry?
I can choose if I want to be extradited? I don't understand.
Yes, you can elect to be returned voluntarily without going through that process. If you decide to waive your right to contest extradition, we will notify the state of Wisconsin. They have 10 business days to come pick you up and return you to Wisconsin to address the case. So,
I will go. The only concern is my kids are here in Florida, my 2 kids.
so who are your kids with right
They're
now?
with their father, but
Okay.
all my family is in Wisconsin. Is there any way they can be transported to my family, or how would?
I don't have any jurisdiction over that. So is your husband cooperative with any of that?
We're not married, and I've been in
Right.
custody since they were born.
Right.
If my family comes to get them, could he stop them? I mean, I don't know how this works.
Well, that could raise an issue. Generally, each parent is entitled to equal rights to the child or children. So is this father, is he cooperative with you or not so much?
He is, but he will not let my family come get them.
Okay, well, that's not extremely cooperative.
They want to be with me, they want to be with my family, and I'm gonna be, 24 hours away.
Right. I don't know what to tell you on that, Ms. Mickelson. You do have the right to consult with an attorney, and I'll be happy to appoint the Office of the Public Defender to represent you so they can explain to you more fully what your options are with respect to the extradition. They cannot, unfortunately, represent you on the child custody issue.
Okay.
So,
Yeah, I will go, whatever's the fastest. You said within 10 days, I'll go. Yeah, definitely.
okay, well, if you feel comfortable with that decision, I'm going to sign an order this morning. They'll take it out to you to the jail for you to sign. If you change your mind, that's fine. But as of right now, provided you sign this, we will notify Wisconsin. They have 10 business days to come pick you up. If they haven't done so, you'll be brought back before me and we'll see what the situation is.
If they haven't come get me in 10 days, whatever.
Right, we'll see you again. And if they're not interested in coming down to get you, we're not interested in holding you in our jail. But if they have something like a plane breakdown or something, they have a reasonable excuse as to why they didn't get here, they could be given some additional time.
Have you spoken to anyone up there?
I don't speak to people, Wisconsin's indicated that they do want to extradite.
At the moment, yes, they indicated they do want to know.
They've told the sheriff's department here that they do want to extradite. So,
One more question. No, I forgot it. I'm sorry.
that's all right. Again, don't know if someone from the public defender's office would have a chance to talk to her
Today or when, Judge?
today. maybe.
I mean, if I can use the jail phone, I can call her this morning in terms of by video
Okay,
potentially.
once we go off the video feed, one of the assistant defense, public defenders will call the jail room there. If we could have her help for just a minute after we go off video, so they can call out there and talk to her.
Yes, sir, Your Honor.
That'd be great. Thank you.
Sorry, I don't remember the question. Do they ever do extradition where they let the person voluntarily drive up there or not?
That's up to the demanding state, so.
Thank you, Judge.
Thank you. Thank you, ma'am. So if you'll just have a seat, I'll have someone call you in just a few minutes. I appreciate that, Ms. Smith.
No problem, Judge.
Okay, did we have anyone else at the jail we haven't addressed?
No, Your Honor.
All right, thank you very much. We're going to switch our feeds, but there'll be a call made out there to Ms. Mickelson. Thank you.
Last but not least.
Well, not quite last, but got a couple of arraignments too, but we'll get you going.
He's in the room next door.
Good. What a morning.
Judge, I'll be heading next door.
Okay, thank you.
Judge, while we're switching feeds, is Gondola still on your docket? Miss? Okay, I know Ms. Keene emailed that, but I didn't know if it came off of your docket. And then I'll wait, my other one's not gonna be here because he's in orange, but I'll do that one.
Who's,
Mr. Mills, the one that we were waiting to see. We're in phase 2 now, so hopefully they'll be able to get something scheduled in orange.
Mr. Mills, we'll just reset again to October.
13th?
13th. We have-
Yeah, that's Monday. No, that's a Tuesday. The 12th is a Monday.
The 12th, set for October 12th.
Thank you.
Oh, there we go.
And then I'm gonna call over.
All right. Can you hear us, Mr. Mendoza?
Yes, sir, can you hear us?
Yes.
Thank you.
We're going to start with Rita Thompson. Morning, Ms. Thompson. If you'll raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
What is your name?
Rita Thompson.
Ms. Thompson, you can see Mr. Dutre over here, I believe, and he has submitted a written plea form which indicates that you want to resolve the charges in case 19 CF 2263 by entering pleas of no contest to the lesser included offense of battery is to count 1, and to resisting an officer without violence is charged in count 2. Is that what you want to do?
Yes.
And State, will you be now processing count 3? Who's the State? Are you-
It is not me.
It's Mr. Moore.
It's Mr. Hamilton, the state.
Okay,
He sent me the spreadsheet.
well, let me see if I,
I'm showing that Ms. Demers is the assigned ASA because it.
I believe we've got a witness. Thank you.
Good afternoon, Your Honor. This is the Spanish interpreter.
Good afternoon, is this Ms. Arroyo?
Yes, this is she.
Good afternoon, Ms. Arroyo. I assume you've been sworn by this point in the day.
Yes, I have, Your Honor.
All right, thank you. We have Mr. Rosario Padilla at the podium at the jail facility. You will be doing interpreting over the intercom system.
Yes.
And for your records, that is 2020 MM 2245. Good afternoon, Mr. Rosario Padilla.
Buenas tardes, señor Rosario Padilla.
Can you hear
Good
us?
afternoon. ¿Nos escucha?
Sí.
Yes.
Thank you.
You were detained in case number 2020 MM2245 with one allegation of battery, domestic violence related.
Usted fue detenido en el caso 20 MM2245 por la acusación de agresión física con respecto a violencia doméstica.
I do find probable cause for your initial arrest.
Determino que existe indicios de criminalidad para sustentar el arresto.
I will appoint the Office of the Public Defender to represent your interests.
Y para representar a sus intereses le designo defensor público.
Before we talk about any conditions of bond, we have a witness present.
Antes de ponernos a hablar con respecto a las condiciones de la fianza, tenemos aquí presente un testigo.
Good afternoon, ma'am.
Buenas tardes.
Good afternoon.
And you are Miss Feliciano, is that correct?
María Feliciano.
Thank you.
I'm sorry. Does she needs to allow me to interpret for the defendant even if she doesn't need my service or if she does?
Okay.
I'm sorry, Mr. Arroyo.
That's okay. Señora, tiene que permitir que yo haga la traducción, sea porque usted lo necesita, pero con todo y con eso es porque el Señor lo requiere.
Yo lo necesito.
I also need her as well.
All right, Ms. Arroyo, if you want to do that over the intercom or...
Absolutely.
Okay.
No problem.
Thank you. Let's swear in this witness, please.
Do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, nothing but the truth, so help you God?
Yes.
¿Jura usted solemnemente que la declaración que rendirá usted en esta causa va a ser la verdad? ¿Lo jura ante Dios?
Sí.
Yes.
Ms. Feliciano, you are present, and the court can consider different types of contact should that be requested by you.
Señora, se encuentra usted aquí presente y este juzgado puede considerar diferentes tipos de contacto si es algo que usted va a estar solicitando.
Most strict form of contact is no contact.
El más estricto sería el de no haber ningún tipo de contacto.
Court may consider something called no hostile contact.
También se puede contemplar algo que se llama contacto sin hostilidad.
In order to consider that, I'll need to ask you a few questions, and then I'm going to ask the attorneys to ask you some questions as well.
Pero para considerar eso, primero tengo que hacerle unas preguntas a usted y permitirle a los abogados que le hagan preguntas también a usted.
Now that you're under oath, will you tell us your name one more time, please?
Ahora que usted ha prestado juramento, vuelva a repetir nuevamente su nombre.
María Feliciano.
María Feliciano.
How are you acquainted with Mr. Rosario Padilla?
¿Cuál es la relación que tiene usted con el señor Rosario Padilla?
Soy su exnovia, pero tenemos una propiedad juntos en la cual los dos vivimos.
I'm his ex-girlfriend, but we share a mutual property in which we both live.
At this time, do you cohabit? Do you live together?
En este momento dado, ¿viven los dos bajo el mismo techo?
Sí, porque los dos somos propietarios de la vivienda.
Yes, because we are both owners of this home.
And that's the home on the Old Kent Circle address?
¿Y es la vivienda en la Old Kent Circle?
No, mi propiedad es en 4976 Paul Mall. En la dirección que dice el juez es la dirección del Clubhouse.
No, my address is 4976 Palmore. The address the judge just mentioned is the one belonging to the Clubhouse.
I see. If Mr. Rosario Padilla was released, would he be staying with you?
Si fuera a ser puesto en libertad el señor Rosario Padilla, ¿se quedaría él a vivir con usted?
Sí.
Yes.
Do you share any children in common?
¿Ustedes tienen hijos en común?
No.
No.
If Mr. Rosario Padilla was allowed to reside with you, do you have any fear of continuing violence?
Si se le fuera a permitir al señor Rosario Padilla de poder vivir con usted, ¿tendría usted temor de que se entablara alguna violencia?
No, porque he vivido con él 12 años y nunca ha sucedido esto.
No, because I've lived with him for 12 years and nothing like this had ever happened.
Were drugs or alcohol a factor in this?
¿Fueron factores en este caso drogas o alcohol?
No, ninguno en la casa tomamos alcohol.
No, neither of the two of us drinks at home.
Thank you for that information. I'm going to allow the Assistant State Attorney and the Assistant Public Defender to ask you questions.
Gracias por esa información. Ahora le vamos a permitir tanto al fiscal auxiliar como al abogado defensor auxiliar hacerle preguntas.
Ms. Feliciano, do you desire to have contact?
Señora Feliciano, ¿desea usted tener contacto con él?
Sí, por favor.
Yes, please.
And do you desire for him to return to the home?
¿Y usted desea que él regrese a la vivienda?
Sí.
Yes.
If something like this were to happen again, do you feel confident that you will be able to call 911?
Si algo semejante fuera a volver a ocurrir, ¿se sentiría usted segura al marcar el 911?
Sí.
Yes.
I don't have any further questions.
No tengo más preguntas.
Any questions?
Nothing from the defense.
¿Alguna pregunta? Nada de parte de la defensa.
Ma'am, you are in the best possible position to gauge whether you feel that you are in danger.
Señora, usted es la que usted es la que mejor se encuentra en la postura para poder saber si se encuentra en peligro.
Based on your sworn testimony today, the court will allow you two to have no hostile contact.
Basado en el testimonio juramentado que ha rendido usted aquí hoy día, se va a permitir que ustedes dos puedan tener contacto sin hostilidad.
The court will permit you to live together.
Y se le permitirá a ambos vivir bajo el mismo techo.
Rosario Padilla, no hostile contact means no raised voices, no putting your hands on anyone, and generally no hostile behavior. Do you understand that?
Señor Rosario Padilla, cuando se dice contacto sin hostilidad, significa que no le puede levantar la mano, no le puede poner la mano encima a nadie y no puede haber ningún tipo de acto hostil. ¿Entendido eso?
Sí.
Yes.
Thank you. The court will set bond in this case in the amount of $500.
Muy bien, entonces se fija la fianza en la causa en $500. Thank you.
There will also be pretrial release conditions that he not possess a firearm or any weapon.
También habrá la condición con el programa de libertad provisional de que esté prohibido la tenencia de ningún tipo de arma de fuego o arma alguna.
Along with the condition that I already announced that we have no hostile contact with the alleged victim.
Y con la condición de la cual ya pronuncié previamente, y es decir, que no puede tener ningún contacto hostil.
Joining us in court today, ma'am.
Thank you.
That will complete our hearing today.
Hemos concluido con la audiencia de hoy.
Ms. Arroyo, thank you for your services.
You're welcome. The interpreter will disconnect.
Eleazar Barrios Roman.
I'm sorry, I'm having a hard time hearing you.
All right, sorry about that. Let me get closer to the microphone. Maybe it's the mask. This would be Barrios Roman. Good afternoon, sir.
Good afternoon.
Sir, you were arrested based on an allegation of trespass after warning. I have read the charging affidavit. I do find probable cause for your arrest. Your bond is set in the amount of $150, and the court will appoint the Office of the Public Defender to represent your interests. Thank you, sir.
150.
Zamir Jordan.
I'm sorry, who?
It's a John Doe, a.k.a. Jordan.
He, we're gonna have to call him at the end. They need to bring him in. John Doe.
That's him right now. Come on.
Oh, John Doe is here.
Good afternoon, sir.
Good afternoon.
We're going to place you under oath. Madam Clerk.
Go ahead.
You can hear me. Do you solemnly swear or affirm to testify the truth and nothing but the truth to help you God?
Can you hear the clerk, sir?
No.
All right. Yeah, talk into that microphone.
Can you hear me now?
Yes.
Do you solemnly swear or affirm to testify the truth and nothing but the truth to help you God?
Yes.
Sir, can you tell me your name?
Zymir Jordan.
All right, thank you. Zymir, it's pronounced?
Yes.
All right, thank you, Mr. Jordan. Mr. Jordan, you were arrested based on an allegation of resisting an officer without violence and making a threat upon a officer.
Can you say that again?
I didn't hear your question, sir.
I said, can you speak louder, a little bit louder?
Yes, of course. You were arrested based on 2 allegations. The first allegation is resisting an officer without violence. The second allegation is that you made a threat on a law enforcement officer of death or serious bodily harm. I do find probable cause for your arrest. I'm going to set bond in count 1 in the amount of $500. Bond in count 2 will be set in the amount of $5,000, and I will appoint the office of the public defender to represent your interests.
Okay.
Thank you. Daisy Munoz.
You can sit down. Who do you have to? Daisy?
We have a Ms. Munoz.
Yes, she's coming.
Thank you. Good afternoon, Ms. Munoz.
Good afternoon, Judge.
Ms. Munoz, you were arrested based on 3 allegations, the first being aggravated assault with a deadly weapon without the intent to kill. Second allegation is discharge of a firearm in public, and the third allegation is child neglect without great bodily harm. Ms. Haston, do you wish to be heard as to probable cause on count 1?
Is count 1,
Aggravated assault with a deadly weapon?
let me pull the affidavit. I know that I had a probable cause argument for the child neglect. That being that the child wasn't in the room, it was clear that it was pointed at a wall. The child wasn't even present in the room. She was never in any danger. And as to the aggravated assault, I believe her husband stated that he was not in fear.
It's my recollection of the charging affidavit as well. State, any additional argument?
No, Your Honor.
Court's going to find that there is not probable cause for count 1. I will ROR you on that particular count based on that finding. State of Florida may still decide to move forward with prosecution on that charge, but as far as your bond as to that charge, you will be released on your own recognizance. Ms. Haston, as to your argument in count 3, any additional argument?
From the defense, I have no additional argument.
All right. Thank you. I do find probable cause based on a culpable negligence allegation as to firing a projectile through the wall with the child in the apartment. So I will find probable cause for count 3 and count 2. Bond in count 2 is going to be set in the amount of $500. Bond in count 3 is set in the amount of $1,500. I will appoint the Office of the Public Defender to represent your interests. State, do we know if a state agency has been informed of this particular incident?
I don't have any information whether or not DCF or anybody has been contacted. Or actually, it does say that DCF was notified by Deputy Cordero, but I don't have the results of if they've made contact yet.
All right, the charging affidavit does not allege any threats towards the children. I think under a culpable negligence theory, there is probable cause for count 3, but the courts can take no additional action as to contact. I'll leave that in the Department of Children and Families' capable hands. So that will complete our initial appearance. Ms. Munoz, you have a bond total of $2,000.
Judge, the state would just ask for no weapons or firearms upon release.
I think a standard condition of any bond is that you not possess any firearms or weapons. If there are firearms in that home, Ms. Munoz, they need to not be there when you get there. You understand?
Do you understand? He said he can't have any firearms.
Okay, that's no problem.
Yeah, if you guys are having difficulty hearing me, I'm talking about as loud as I can into this microphone, so.
Yeah, I don't think it's on your end. I think it's the speaker here is not very loud.
I'm happy to clarify anything. The last thing that I said, Ms. Munoz, is as a condition of your bond, you're not allowed to have any firearms in the home. So that will need to be gone by the time you get back to the home. Do you understand? Yes, ma'am. Thank you. Austin Owens. Do we have Mr. Owens? Austin Owens? Thank you, officer. I hear that. Good afternoon, Mr. Owens. Can you hear me okay? Did you say something in the microphone? Because I didn't hear you. All right. Thanks. Mr. Owens, you were arrested based on an allegation of battery. I read the charging affidavit. I do find probable cause for that allegation. Your bond is set in the amount of $500. I noticed that you are also out on a driving while license suspended charge in 2020 CT 1265. The bond in that case is going to be revoked. However, I am going to set bond in that case in the amount of $500. And I will appoint the Office of the Public Defender on your new case in 2020 MM 2243.
Thank you, so I can bond out?
Yes, you can. However, as a condition of your bond, you're not to go back to that location. You can't have any contact with that person.
That's my living address.
Okay, well, I'll let you go back there one time with law enforcement to get your personal belongings. You can modify these conditions of bond in front of your trial judge if you can show that that person is no longer there.
They don't live there.
Okay, that's not what the charging affidavit said.
Understood, thank you.
All right, thank you. Darby Rodriguez.
Good afternoon, Your Honor.
Good afternoon, Mr. Rodriguez. Mr. Rodriguez, you were arrested based on an allegation of battery domestic violence related. I have read the charging affidavit. I do find probable cause for your arrest. The court is going to set a bond in your case. The bond is going to be set in the amount of $1,500 plus pretrial release with the special conditions that you have no contact with the alleged victim, that you not return to the property, that you possess no drugs and consume no alcohol as a condition of your bond, and that you possess no weapons or firearms as a condition of this bond. Do you have any personal belongings at that property?
Yes, I do. I have all my belongings there.
Okay. I'm going to allow you to return there one time with law enforcement to get some belongings that will tide you over until you can get in front of your trial judge. And if there's some modification, that decision will be made by your trial judge. But I'll allow you to go back one time, but you have to have law enforcement there so you can get some stuff. You understand?
Yes, sir.
All right. Thank you, and I will appoint the Office of the Public Defender to represent your interests. Jose Santiago.
Do you approve? Who did you call?
Jose Santiago.
Good afternoon, Judge.
Good afternoon, Mr. Santiago. Mr. Santiago, you are charged with the offense of you were arrested for the offense of failing to obey a law enforcement officer's lawful order to stop. I have read the charging affidavit. I do find probable cause for your arrest. You do qualify for pretrial release I am going to release you to the pretrial release program, and I will appoint the Office of the Public Defender to represent your interests. So they'll explain to you what that means, but they'll have some questions for you, okay?
Okay.
Straight PTR. Joshua Taylor.
And on this charge, I'm gonna waive the reading of the charges.
Understood, Ms. Hazen. Mr. Taylor, I have read the charging affidavit in this case. I do find probable cause for your initial arrest. You are currently without bond. You are going to remain without bond so you can get in front of your trial judge, and I will appoint the Office of the Public Defender to represent your interests. Thank you. Those are all the folks that I have on my afternoon docket.
We had Courtney Jenkins on an out-of-county warrant out of Orange.
I understand that he bonded. I think Mr. Jenkins' friends or family have already posted a bond.
Okay. Okay, thank you.
All right, thank you. That will complete our afternoon docket. Thank you.
Thank you.